I will call to order the meeting of the Planning Commission for Wednesday, December 18th, 2019. We'll start with the Pledge of Allegiance. Commissioner Wu, would you please lead us in the pledge?
Sure. Members of the Public Commission, please join me for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Gabriel, can you call the roll, please?
Yes. Commissioner Brown?
Here.
Commissioner Kaczynski? Here. Commissioner Talley?
Here.
Commissioner Wu?
Here.
Chair Pro Tem Crandall?
Here.
Vice Chair Blackwell?
Here.
And Chair Brolin.
Here. Before we move on, I have a sneaking suspicion that most of you are here for item 8B tonight. Just two quick things. One is, if you didn't notice, staff has done a very nice job of summarizing the public comments that we got on this issue in a few pages. We have about 60 pages of public comment, and they've summarized them. If you haven't looked at that, may be something you want to take a quick look at if you plan to, follow hearings or speak tonight, as it might, do something to address any, questions or issues that you have on your mind. The second thing is we do have a little bit of business before we get to yours. So if you could keep, shuffling of papers and such to a minimum so the Commission can do its business, we'd appreciate it. So thank you in advance for that. Item 4, special orders of business, we have none. Item 5, we have 2 sets of minutes. First, the minutes of the regular study session of December 4th. Is there a request for change or a motion?
Motion to approve.
Second.
Motion by Don, second by Mike. All in favor? Aye. Any opposed? Passes unanimously. And we have the minutes from the regular Planning Commission meeting of December 4th, 2019.
I'll make a motion to approve. Motion to approve.
Okay, we'll just hit the pause button for 1 second. It looks like I missed this. Commissioner Krasinski was absent the last one, so that's an abstention, so I apologize. I'm sorry, please go ahead.
I'll still make my motion to approve the minutes of the regular session of the regular meeting of the Planning Commission from December 4th.
The second.
Motion by Jason, second by Mike. All in favor?
With Chris. Aye.
He'll abstain, yeah. All in favor?
Aye.
Aye. Any opposed? Passes unanimously with 1 abstention. Item 6, oral and written communication. Members of the public may address the Commission on matters of public interest which pertain to the city and are not otherwise on the agenda. If you wish to speak, please step forward to the microphone, and if you desire, state your name and/or city of residence for the record and make your presentation. Please limit your presentations to 3 minutes. Is there anyone who'd like to speak tonight on something that is not on our agenda? Do we have any no cards? Okay. Next item, consent calendar. We have none. Item 8, public hearings. And our first item is 211 Calle Pintoresco discretionary sign permit. Okay. Erin, the floor is yours.
Yes. Good evening, Commissioners. Chair Rulin, my name is Erin Guy, Community Development Technician on staff with the city. The project at hand tonight is discretionary sign permit 19-243, a request to allow or consider 4 individual signs on an existing single-tenant building in the Rancho San Clemente Business Park. The subject property is a 1.2-acre corner lot at 211 Calle Pintoresco in the Rancho San Clemente Business Park, also within the Rancho San Clemente specific plan. The existing building is a 2-story single-tenant building, which houses YT Industries, an international bicycle manufacturing company. The proposed project includes a request to legalize the existing signage on site, as the signs were originally constructed without a permit. In total, there are 4 signs proposed. And when 4 or more signs are proposed on one single-tenant building, the zoning ordinance requires a master sign program. So signs A and B are made of black acrylic channel letters, and those are interior facing towards the common parking lot and the interior courtyard. Signs B and C are painted directly on the building in matte black acrylic paint and are exterior facing towards Calle Pintoresco. So each sign is under the maximum allowed sign area of 64 square feet, and the total sign area on site would be approximately 176 square feet total, where the zoning code allows for a maximum of 441 square feet on site. So the signs meet all required zoning standards in regards to size and location. Signs C and D are located on the exterior corners of the building facing out towards Calle Pintoresco. This design is mimicked throughout Calle Pintoresco and is shared as a common neighborhood characteristic for sign placement. The size of the exterior facing signs is appropriate for the scale and massing of the two-story building. The Design Review Subcommittee did review the project and had two main recommendations for the project. The first recommendation was regarding the proposed illumination of channel letter sign A. Initially, the project proposed sign A to be illuminated, side halo lit to 11,000 lumens. DRSC recommended the alteration of the illumination to be 2,000 lumens and halo lit, or for the illumination to be removed altogether. The applicant chose to remove the illumination, and now the project contains no proposed illumination of any kind. DRSC also recommended the removal of a YT Industries logo in an existing mural on the site. The applicant has removed all trademarked logos from the mural and received a mural permit for the remaining images. So staff recommends that the project be found categorically exempt from CEQA pursuant to section 15311. And staff recommends that the Planning Commission adopt resolution PC 19-042, approving the discretionary sign permit at 211 Calle Pintoresco, DSP 19-243. That concludes the presentation.
Thank you. And the applicant is not here this evening, so does anyone have any questions for staff?
I do.
Please.
So Aaron, do we have any views from La Pata?
Not in the slide, no. I do have some here in the packet that I could find for
Could you pull
you.
it up? Maybe Gabriel, can you pull it up on Google Maps? Just want to get an idea. I know that building is somewhat set back, but I just want to see how much of it is actually visible from that corner. Yeah, I would think so, but I just want to make sure.
You want me to grab that, Gabriel? It is that building there in the corner, YT Industries, so
So maybe if you could drop a pin right.
sure, I'll see if we can.
Excuse me.
So that's the building there. We'll scoot up a few and see if we can.
Yeah, maybe on the other side of the road,
That
the
there.
downhill part.
These red umbrellas that you can see are the interior courtyard at 211 Calle Pintoresco.
So where's the front face for A and B?
So A and B face those red umbrellas in the interior courtyard and common parking area.
Okay. So, Aaron, could you just go up La Pata a little bit on that same side of the street and then look back at the yeah. So you can't see it at all. It's completely screened. All right. Thank you.
Sure.
Okay. Any other questions for staff? All right, seeing no other questions, I will open the public hearing. And Eileen, do we have any cards on this item?
Yes, sir.
Okay, then I will close the public hearing and open it up for Planning Commission discussion or motion. Bart?
I make a motion to,
Oh, what's that? Oh, okay.
I make a
So,
motion
Zen, go ahead.
to approve the resolution number PC 19-042, a resolution of the Planning Commission of the City of San Clemente, California, approving discretionary sign permit 19-243, a request to establish a master sign program for existing single-tenant building at 211 Calle Pintoresco.
Second.
Motion by Zen, second by Don. All in favor? Aye. Any opposed? Passes unanimously. All right. Our next item, 8B, zoning amendment 19-189, small cell ordinance. And Katie is our staff member on this one. Thank you. So the floor is yours for your presentation.
Thank you. Good evening, Chairman Rulin and Planning Commissioners. Katie Crockett, Associate Planner. Before you this evening is an ordinance to amend the zoning code and adopt design and development standards for small wireless facilities, otherwise known as small cells, in the city of San Clemente. This ordinance came about because of new rules adopted by the FCC related to how cities process applications for small cells. The rules include, first, new shorter shot clocks. Shot clocks are counted from the day the application is submitted. They also include time for appeals. Therefore, the appeal period and time for an appeal must be accounted for, meaning that staff cannot utilize the full shot clock time to review and prepare a recommendation. The second is they established maximum fees of $500 per application for existing support structures, or $1,000 per application for new support structures. The third is that the FCC also requires that any design or aesthetics requirements imposed by cities have to meet the following four tests. That the standards must be reasonable, objective, no more burdensome than those applied to other similar types of infrastructure deployments, and published in advance of the application being submitted. Currently in San Clemente, like for traditional larger cell sites, small cells would require either a CUP or a city antenna permit, depending on where the proposed site is and its design. Both processes require DRSC review and a noticed public hearing. Cell sites are permitted in all zones, and most development and design standards are determined through the discretionary process, meaning that they are neither objective nor published in advance. So the draft zoning amendment consists of three main parts. The first is the ordinance itself, which amends several sections of Title 17 of the San Clemente Municipal Code. The second is the design and development standards, which establish specific, reasonable, objective design and development criteria and are referenced in the ordinance. The third is the standard conditions of approval, which will be applied to all wireless permits and are also referenced in the ordinance. The goal of the ordinance is to ensure safety by requiring proper permitting reviews and compliance with radio frequency exposure standards. To protect aesthetics by creating reasonable, objective design criteria, which also helps with the goal of minimizing discretion involved, which facilitates compliance with restrictive shot clocks and fee limitations imposed on the city. This process started in May when the City Council voted to initiate the zoning amendment. Throughout the process, the zoning amendment has been agendized on a number of meetings at the City Council, DRSC, and Planning Commission. To keep interested parties appraised of the status of the zoning amendment, the city created a small cell webpage and maintains an email notification list used to notify parties about the process. Staff has received public comment throughout the process. Written comments received by staff were compiled and provided to the commission, some by email on Thursday, and the whole packet, including ones received since then, was on the dais tonight. Staff addresses some of the most common or biggest issues brought up in the public comments in attachment 2 of the agenda packet. Every public comment was read and considered. That doesn't mean every public comment was incorporated into the ordinance. Staff believes the draft before you today balances the objectives of the city in regulating time, place, and manner of these installations, as well as establishes both meaningful and reasonable objective design criteria that will promote consistency, both with the character of our city and aesthetic consistency from installation to installation. There are several key elements of the ordinance: process, appeals, location, and design that I'll talk about briefly. The ordinance would establish a new wireless permit for all small cell applications. Determinations would be made administratively by the city planner. While there is no public hearing, due to feedback from the public, noticing has been included. Both a notice of application, which would be sent by the city within 10 days of submittal of an application for a wireless permit, and a notice of date of decision would be sent by the city about 10 days before a decision is made, notifying the recipient the date a decision will be made. This notice is sent since there's no scheduled public hearing, and the appeals period is shorter than a standard appeal period. Appeals would also be administrative, determinations being made by the Community Development Director. Appeals to the Community Development Director must be filed within 3 business days of the initial decision. There are a variety of locational criteria. Key criteria include minimum separations of 100 feet to residential and mixed-use property lines, 500 feet to school property lines, and 300 feet from cell site to cell site if a new support structure is proposed, or 200 feet if existing or replacement support structures are used. They are also not permitted within very high fire hazard severity zones. The standards contain general design criteria as well as specific design criteria for certain types of installations, such as streetlights or utility poles. The criteria provide height, size, and mounting location for pole-mounted equipment parameters, as well as for ground-mounted equipment, although ground-mounted equipment is prohibited in the right-of-way unless an exception is granted. Exceptions to any of the criteria can be requested if the applicant shows that strict adherence to the standards would inhibit their provision of a particular personal wireless service or otherwise violate state or federal law. Staff believes the standards are reasonable on their face, since, as drafted, there are large areas along major rights-of-way where the facilities can be located without an exception, and the design criteria protect aesthetics in ways that, in most instances, should be technically feasible. In the event that is not the case, for a particular site, the applicant could request an exception. Written public comment received by staff was compiled and provided to the Commission and posted to the website. Additional written public comment received after the compilation was also provided to you, but not posted to the website yet. Some of it we just got this evening. Throughout this process, staff noticed several common themes in the public comment. As I previously mentioned, I tried to address those in attachment 2. Staff endeavored to incorporate planning commissioner feedback as well. Specific feedback and how it is addressed or not is summarized in attachment 3. Staff was unable to address a couple of points the commission raised, and I want to briefly address those. A commissioner expressed interest in requiring trees around new small cell facilities. Staff agrees, and I think the general plan and design guidelines generally support this. However, this piece would need additional thought for a number of reasons. First, many of these facilities will be in the right-of-way, and Public Works would need to agree to this requirement, which thus far they've been hesitant to do. And second, while in some cases this may help to screen a facility, in others it may have other unintended consequences, like actually making it, almost bigger, like in a view, for example. Since the design criteria need to be objective and published in advance, this would take some more finesse to figure out in which instances trees would be required and in which they would not. The second item was the general desire that significant gap language be left in the ordinance. Because of the direct conflict with the FCC order, notwithstanding the court decision, staff with input from the city attorney's office chose to remove it at this time, given the current state of regulations. However, it could be added back in if and when any additional court decisions or implementing rules clarify this conflict. The amendment was drafted with the goals of protecting aesthetics and maintaining safety, while providing objective standards and a streamlined review to facilitate compliance with FCC-mandated shot clocks and fee limitations. Staff endeavored to respond to and incorporate feedback received from the public and the wireless industry, as well as planning commissioners, to the extent that the feedback could be incorporated without either being too permissive to the detriment of aesthetics or too prohibitive to run afoul of the California Public Utilities Commission or FCC regulations. So as we consider these draft regulations, I leave you with a very general list of things that are within the city's control with regard to regulating small wireless facilities and those that aren't. For example, the city can regulate locations based on aesthetic concerns, as long as those regulations pass those 4 tests: reasonable, objective, et cetera, et cetera. But it cannot base any separation requirements on safety concerns related to RF. That is reviewed on a site-by-site and application-by-application basis, and our ordinance cannot take that into consideration. These general rules have a whole host of implications for this ordinance, which staff and the city attorney's office has arduously tried to examine each of our requirements against. And the result is the draft before you today. With that, I'll conclude staff's presentation, and I'm available for questions.
Thank you, Katie. Bart?
For the public, could you go over the appeal process very quickly?
Yes.
And while we're discussing appeals, can you talk about the cost of the appeal as well?
Sure. Well, I'll talk about the cost first because that's the easiest. Right now, we do have an adopted fee. Those are adopted by resolution for appeals. For a public appeal, it's $500 some odd dollars. For an applicant appeal, it's $1,200 some odd dollars. We will be looking, because we do need to adopt a new fee for the wireless permit, we will be evaluating whether we need to adopt different fees for the appeals, but right now that's how it stands. Public appeal would be, I think it's $538 or something in that range. Important to the appeals process is the noticing, because the appeal process is the appeal period is only 3 days from the date of decision. But given that all property owners within 300 feet would be noticed of the application immediately after it's submitted, within 10 days. And then we would provide them with an additional notice ahead of the decision telling them the date that it would be decided. So then they will know in advance when they would need to look for that decision and file their appeal. Appeals can be brief. The basis for the appeal can be brief. It can be added to later. The only caveat is that appeals cannot be based solely on concerns related to RF.
Thank you. Don?
Yeah, just for public consumption, I think for the record, city planner or Katie, the fees are set by city council, I think by approval
resolution.
by city council, so everybody should know that this body doesn't have anything to do with that. And just, I think we've noticed for the record, but for the audience, we did receive some 60 pages of notes that covers every email sent to the city from 18 August through 5:20 p.m. tonight. I'd like to make sure that's entered into the record that we received that. And I want you, the audience, to know that. Thank you.
Okay, Mike?
Yes. Katie, we're going to mail out 2 notices to the public, correct? 1 notice of application and then 2 notice of determination. Why couldn't we do all of it in one? Because if we're held to the 60 or 90 days, couldn't that be included in the notice of application, all in one? Because if we're held to that 60 or 90 days anyway, why use staff time and resources if that date's not going to change, or if it's not intended to change?
The simple answer to that is that if we provide a notice of application within 10 days of submittal, we don't yet know the date a decision will be rendered. We have 10 days to determine whether the application is complete or incomplete, but otherwise we don't necessarily know the date the decision would be rendered.
Yeah, that makes sense. Okay, and then could you walk us through the exceptions process, any findings that need to be made, and how that whole process will work in terms of final review and final determination?
Sure. Exceptions requested by the applicant would need to be requested by the applicant at the time of their initial application. That helps us, again, comply with shot clocks, so we're not evaluating a lot of additional information after our shot clock has already started. You'll find the findings in Attachment 5, the draft ordinance. I believe it's Exhibit C. And the exceptions do not extend out the shot clock. We still have the 60 or 90-day shot clocks. And essentially with the findings, I do want to find that reference for you. It's actually in Attachment 5A. The findings for an exception, there are 2. One, that the denial of the facility based on the applicant's application's noncompliance with a specific provision or requirement would violate state law, federal law, or both, and that the exception deviates from the ordinance, this section, or the design and development standards to the least extent necessary to prevent a violation of state or federal law or both. i.e. there are no viable, technically feasible, and aesthetically equivalent or superior alternatives that comply with this section and the standards that could prevent the violation of state or federal law.
So we would be then turning the burden back to the applicant to demonstrate that.
That's correct.
And that would be at the discretion of the community development director to determine if that's
It would initially be the city planner,
city planner.
and then on appeal, the community
Appeal,
development
okay.
director.
Lucky city planner. Okay, and then the, so the fees that we're charging, so we have a max of $500 or $1,000 for a new. Does that include all fees? Like, for example, if there's an encroachment permit that's necessary, would that be extra?
Yeah, I believe it, so as it's, right now, yes, it would be in addition. I believe that, you'll notice that there's no fee resolution before you because we're still hammering some of that out, but I believe the intent is that all one-time fees, so any fees that they would need to pay to get permits in hand to construct the facility should be under those safe harbor thresholds of $500 or $1,000.
Okay. 2 more questions? Just had. Some cities will require a photometric study to be done. So anytime there's light patterns to our streetscape, we've got to have continuity and proper coverage. And it's not uncommon for a jurisdiction to ask for a photometric study to be done. That would be, that cost would be borne by the applicant. Have we thought about that at all, or how are we ensuring the quality of our lighting in the streetscape?
That's something that the Public Works Department reviews when they issue encroachment permits, which would still be a requirement in cases where these are in the public right-of-way. And they do have standards based on, the brightness of that particular bulb, the height of the standard, and how far the standard says they're to be placed on any particular street. So that is something that's covered, even though
Okay.
it's not in the ordinance.
Okay.
Because Public Works isn't necessarily reviewing the wireless permit. They're reviewing it in the encroachment permit phase.
Okay. And then finally, at this point, for me, I may have another question later, I'm going to hold on, but the separation requirements that we came up with, and we've got, and there's been a lot of discussion in letters from the public, and our own draft ordinance here. We've talked about it before, but the different distances and why there are different distances. And we've got sensitive uses, period. Why is there more for one and less for another? Why don't we keep it consistent across the board?
Yeah, so the 2 sensitive uses that we've included in our ordinance are residential properties, and that includes mixed use, as well as schools. The reason that the standards are different is because, we started somewhere in the middle when evaluating what an appropriate separation distance would be. We started, in the middle, about 500 feet. And upon reviewing those buffer maps, staff felt that it did exclude a substantial portion of most of our major rights-of-way. And so we felt that it needed to be brought down. We did not see a similar effect with schools simply because the area of schools versus residential in this city is obviously proportionally much less.
Okay. And I'm sorry, forgive me, I don't recall, but is it the distance from school, the
Property
distance to
line.
the property line? Okay. Okay, that's all I have. Thank you.
Jason?
So I've got a couple of questions, probably more for council. I don't know if that's appropriate. It's at the staff level. So did we incorporate any of the order that came out on December 4th from the FCC regarding their new proposed rulemaking? It's been published in the Federal Register.
Yeah, the FCC order, or the notice of proposed rulemakings relating to RF emissions, that hasn't impacted really anything in this. We can talk with the city about it, but they're not really changing. As far as I know, they're not really going to be changing any of the standards or making them, I guess, extending additional authority to local governments.
Well, I mean, I think they actually did change a lot of the emissions testing requirements and the exemptions from certain emissions testing requirements.
So they eased up stuff on
They
the
did.
industry. But that, like I said, it doesn't make it any easy, it doesn't allow the city to do anything that it was not allowed to do previously. If anything, I guess it would impact the RF testing that the expert will do as part of the application process.
Right, so that's my question is, and I read through this, fell asleep several times and woke back up. And my concern, obviously, is that when we adopt an ordinance, it's an ordinance that's, or our recommendation to council, it's a defendable
Right.
ordinance, right? That
Yep.
doesn't get challenged and does the best that we can do. And so it appears that they talk about RF emissions testing, if it's not covered under one of the exemptions, is simple calculations. And yet, we're talking about requiring an RF emissions test, which seems to be more restrictive or more demanding than what the FCC is calling out, at least on this.
So,
Is that-
as far as I know, it hasn't changed in terms of the city's ability to be able to request it as an application requirement and then as a condition of approval. In terms of needing to amend that and how that would relate to the ordinance, the app form will be kept separate from the ordinance, and the ordinance will just be used to kind of authorize the city to issue it. So that kind of works out in the event that we need to pivot it somehow. And then with regard to the conditions of approval, I don't think that there's anything that probably would be an issue, but the wording kind of in the intro part of the conditions allows for the city or the approving authority, so depending on who's actually approving it, to amend that list as needed. So in the event that something had to be tweaked later, it could be done then, but as it's written, we didn't see anything that would necessarily need to change at this point.
Okay, and I've got a couple of other questions for you, which might as well just keep
I'm
on
here.
going here. So in the original, the original order about the small cell sites and kind of why we're here, one of the statements that the FCC utilized was that they wanted to make sure that applicants could predict in advance what conditions would be used, right? And I see us talking a lot about, reasonable, objective standards, and in some of the comments that we've received from industry, they talk about some of the use of the terms that we have, such as best industry practices for stealthing and things like that. If it's the best industry practice, is that predictable? Is that something that an applicant could understand what the best industry practice is so that they could not be guessing?
Right, so I think that's a bit of a topic of debate. I know I've seen, after reviewing a lot of this, right, that similar ordinances and design standards get similar comments from the industry, and they do often hone in on stuff, like you said, like such as like minimize the view, or like the least visible means possible or something to that extent. Usually we kind of classify those as statements of general intent and then say that the rest of the design standards are the city showing how the carrier should go about doing that. So I don't think that it, depending on how that statement is potentially applied, I guess if an application was solely denied off of that, perhaps there would be more of a challenge. But if it's just used as a statement of general intent to kind of convey the message the city's trying to get across throughout all of the specific standards that follow, then I think it's less problematic. And in general, as you noted, the city's always tried to strike that balance between how objective and reasonable, and there's been times where I've seen cities try to go kind of above and beyond, and carrier comments have been essentially that it's too much, like it's too much, it's too restrictive, or it's too much detail, essentially. There's no room for leeway for different designs, and so you almost lose both ways to an extent, or you'll hear potentially a little bit of pushback either way. But yeah, those generalized statements, as long as they have kind of specifics supporting them elsewhere, should be okay. But if that's all you're relying on and you didn't have any other size limitations or descriptions on how to minimize view impacts, then it could be more problematic.
Okay, and then I wanted to follow up with you on Commissioner Blackwell's comments about the 100-foot separation and the 500-foot separation that we have from schools. I guess I'm kind of curious as to why we have, what's different about the schools versus the residential property? If you can give that to me in a legal standpoint so I understand what we're resting our case on, I would appreciate that.
So any separate, again, the FCC was not specific when it came to spacing requirements. They essentially said, you know, some of them could be justifiable and some of them may not. And in terms of different, you know, buildings or structures or properties and how far away you have to be, it just has to be based on aesthetics. From the legal perspective, it has to be a design standard. I guess, you know, or potentially, I suppose you could try to make some sort of, oh, well, this could fall onto something, but generally, these are design standards and they're aesthetic standards, and so, you know, the cities kind of take our legal advice and they decide.
So what's the difference in a design standard? What's the aesthetic difference there?
From a legal perspective, that it's kind of, I just advise the city as to what what the law is regarding those standards. I understand what Katie was saying in that they're trying to balance out what the city feels from an aesthetic point of view should work, and then what the carriers are telling them is not technically feasible, like this will not work in practice, because city staff, you know, have the technical expertise that Verizon or AT&T have, obviously, and so they kind of have to balance all of that feedback. And I think hearing from the carriers, well, you can't be so restrictive that we have nowhere to go, and then also wanting to, you know, hear the public, and I think everyone's sentiment that we've heard over the meetings say that they don't want these to appear everywhere and kind of be visually intrusive. It seems like this is where staff felt was the balance.
So you think that keeping them 500 feet away from schools is less visually intrusive?
So there's no definitive legal answer, given that the order is new and courts haven't really interpreted it. So I can't point to say, well, you know, in this case, the court decided that 300 feet was reasonable because here are the facts, and then you can liken or dislike in your situation, right, or a specific site to those facts. We really don't have much to go off of, so really what we can just say is, you know, any spacing requirements, they just have to be reasonable aesthetic standards, and you know, you can't be, as Katie said, you can't base them off of RF emission effects.
So is it your professional legal opinion to this body that by placing it at 500 feet from schools and 100 feet from residents, we have a legally defensible position?
You can't give a cut and dry answer. There isn't a yes or no answer to that question, which is probably the answer to a lot of legal questions.
Well.
So it really hasn't been tested. To say this will definitively hold up under any circumstances or this will not hold up under any circumstances, you just can't do it from a legal perspective because we don't know how courts will apply the quite general regulations that the FCC has laid out for how these aesthetic standards are supposed to go.
Do you feel good about it?
I mean, that's not my call, I don't think. I feel like that's outside my legal opinion as to say whether or not, like, oh, 500 feet is good or 300 feet is good, or.
Okay, well, let me ask it another way. In your legal opinion, is 500 foot a legal requirement for us to put in there?
Well, nothing's legally requiring you to do any of this. I mean, you just have to set whatever standards you feel are reasonable, objective, and not more burdensome than those placed on other types of infrastructure, and publish in advance of receiving an application. That's the guidance essentially you've gotten from the FCC.
And is that more burdensome or more restrictive than other types of utilities?
Well, that comes to another point of ambiguity, which is what do the FCC mean when they said infrastructure? So our argument would be that means telecom infrastructure. So how do you treat other telecommunications infrastructure? This is the FCC. We're talking about antennas. I've heard the industry repeatedly say that they feel it's any type of infrastructure or utility infrastructure in the right-of-way. So we don't even have a clarification as to which that would be. So I don't know how, I can't really give a definitive answer there either, unfortunately. Okay. It just hasn't been tested. Just have to wait and see.
Are we proceeding with your legal advice?
We've worked with the city and we've given them our input. As we do with all of our clients that have worked on these, we kind of go over all the law and we help filter industry and public feedback and commission feedback, council feedback, and advise them as to the law, and they kind of decide what's best for the community.
So since we're the body, and are we following your advice?
I mean, yeah, we've given our legal opinion to the staff to develop it.
Well, I mean, I want to make sure that when we're looking at something here, that we're actually, following the legal advice that's been given to the city. So the draft that we have in front of us today,
Right.
is that consistent with your legal advice?
I mean, well, without getting into details as to what we've talked about, right, with staff in a public forum, we have discussed this, essentially the ambiguity that comes from applying this order when no courts have interpreted it. So I can't look at it and say like, yes, I can definitively tell you in our legal opinion that this will not cause any issues, or I can tell you that this will definitively be a problem. We just don't know. I can just say this has been developed with our legal advice.
But I'm just
I
curious,
think
are
that
we
it factors
following?
in everything, but there's so
I
much.
want to follow your legal advice. Am I
Okay.
following your legal advice if I adopt this ordinance tonight?
Well, I guess it depends. Like, you would have to ask me about a specific one. And my answer, for example, to the spacing requirements, my legal advice essentially would be to a given spacing requirement. We do not know definitively what would or would not comply with the FCC order because the FCC didn't even seem to know, and they certainly didn't articulate that for the public. So then it becomes a matter of if you face a legal challenge, uncertain. Could be a facial challenge, meaning right in the beginning before it even gets applied to a specific installation. Could be an as-applied challenge, so this one installation site gets denied because of that, then you get sued. And my advice would be the larger radius in which you restrict them could be more problematic because, as the carriers have said, they want to go somewhere and they can't go there, and they're going to make an argument that they need to go there, then it could cause more problems. But I can't definitively say this will or won't cause problems. It's just not something you can do.
I understand you can't.
So let me, we're lucky we've got two attorneys,
Well,
two
but-
city attorneys here today, so
Well,
let me
but-
just toss this to our acting assistant city attorney.
Sorry.
And get some input from him as well.
Sure. Thank you, Mr. Chair, and Commissioner Talley, if I may. Just to, again, remind the public about the way our office and staff and the public and the commission work on this is that, our office reviews all the ordinances that the city staff develops with the commission's input and the public's input. And wireless ordinances are as tricky as they get for two really big reasons. One, as Katie explained, as Andrew has explained, and as I believe you've explained through your questions, there are a number of restrictions both under state and federal law. But there's a second complication, and that is that these orders that come forth, as Andrew has explained, have very little, have not yet run through the courts. And so, our wireless team does a good job in terms of trying to work with the city to determine what is the most legally defensible means that also fits with the city's interest in terms of aesthetics, neighborhood compatibility, but without stepping on those policy considerations. So I think it's absolutely fair to say that the ordinance that's before you has been vetted by our office, given those very tricky and complicated factors here, and is in fact legally defensible from our review at this point. Should the law change at some point, we'll of course recommend revisiting it, but given the newness and the restrictions, our office has reviewed, and we believe it is in fact legally defensible.
So we are following your legal advice if we adopted the ordinance that's in front of us today?
Correct, yes.
Okay, thank you.
Okay. Zen?
I have a few questions. Since we are talking about legality, so I address that first. So my understanding is...
Excuse me, Zen, forgive the interruption. I wanted to remind the members of the public that unlike some of the earlier hearings that we had, which were study sessions and less formal, this is a formal hearing, so please avoid making public comments or interrupting staff or the planning commission so that we can move through the business at hand. Thank you. Sorry, go ahead.
So FCC's order is very friendly to telecommunication industry. And they kind of set the bottom of the legal envelope, if you will. So that's, the bottom line is our ordinance cannot materially inhibit their ability to provide a service. That's a flaw. On the other hand, the city has very wide latitude on land use about how we want to regulate our land use. And usually court will defer to a local jurisdiction on that. So you do feel that this current ordinance fit well in the middle of that envelope, do you?
Yeah, so just to clarify some wording for the record, that you're right, correct, that the FCC says you cannot materially inhibit service. Ultimately, they're interpreting the federal law, which says that you cannot prohibit or effectively prohibit the provision of personal wireless services. The Ninth Circuit, which is the federal Court of Appeals, has said that the test for that is a significant gap, least intrusive means test, which I know we've kind of discussed before. I don't have to get into too much, but it's not definitively clear that that materially inhibit standard would be the appropriate one to apply, at least not for if any sort of legal challenge arose here. But you're correct, that's what they say. But yeah, like David said, you know, we gone through this, we've reviewed it, provided feedback to staff, and tried to incorporate everything that they've heard from the commission, the public, and the industry, and as far as we, you know, our knowledge to this point of the FCC order, and try to incorporate all that.
Okay, thank you. My other question is for Katie. Mrs. Crockett, I'd like you to explain to us the exception, and do they apply to historic district or future historic district in a view corridor? I understand that the ordinance says they are not allowed, but in the worst case, can an applicant ask for exception?
Yeah, the applicant can ask for an exception to any part of the ordinance or the design and development standards that inhibits their ability to provide service or a level of service. We do have some stronger language in our ordinance regarding view corridors, as well as sites that would be in proximity to historic resources, not just historic districts. And so I think the ordinance makes clear that those are more important. So when requesting an exception, where they have to prove that this is, you know, this deviates from our standards the least, because those things are stated specifically, they would have to take exception to each one of them.
Can we ask them to just put the antenna not in the right-of-way, and they can go to a private property? For example, on South El Camino Real, there's a hotel called Little Inn. A while ago, Verizon installed a tower on the top of a roof, and they completely shielded, and they actually made a nice architectural feature, which is kind of a rotunda type of a thing.
There's nothing stopping, as far as regulatory, there's nothing stopping an applicant from putting a small cell on a private property. However, we can't tell them they must put it on a private property versus in the right-of-way, because wireless carriers have certain rights to the right-of-way per the California Public Utilities Commission.
Okay, and the other day when I did some research, and I'm bumping into articles, Swisscom, a major telecommunication in Switzerland, collaborated with Ericsson, and they developed a all-in-ground solution that's usable for high-density urban environment. Basically, they put the radio as well as antenna in manholes. Everything is underneath the ground. All you see is the cover of the manhole. So in the worst case, and they need a service in this view corridor or next to historic resources, and that would be a solution.
It could. I don't have any direct knowledge of this Ericsson and Swisscom, I think you said this technology. It's not something that, to my knowledge, that we've seen here in the U.S. I don't know if that makes a difference, but certainly as industry best practices evolve, we will be expecting that those are applied here. And this is one of the reasons that we included the design and development standards separately as a separate document that's referenced in the ordinance, because it only needs to be adopted by resolution of the City Council as opposed to changing the code again, which makes it slightly easier for us to amend in the event that we should be asking for something like that.
Okay, and then can you show us the map of with all the proposed distance and spacing requirement?
So this shows dark bluish schools. The light blue around it is the 500-foot buffer. Dark gray is residential properties. The light gray, which we can't quite see here because it's not zoomed in enough, would be the 100-foot buffer around those properties. And then mixed use is in purple. Light purple would be the 100-foot buffer. Is there any particular area you'd like me to zoom into so we can see it a little bit?
No, I want to see the overall city. As you explained in the report, almost all the arterial roads will be available for the microcell. If not on both sides, then one side will be available. The only place I see that pretty dense and white, black blob is Forest Range and maybe southeast San Clemente. And then Interstate 5, that's a infrastructure telecommunication companies can use, can they?
Well, I don't know because the city wouldn't be involved in that. That would be Caltrans.
Okay. And in case that there's just make sure, when we see the black area, if the applicant put a microcell tower at two ends of the dark area, assuming that the coverage, let's say, those microcell coverage can go up to a mile, even if we say the coverage is 1,500 feet. So as long as the blacked out area is shorter than 3,000 feet, they'll be okay, because they can put cell towers on both ends and cover the middle, can they?
I couldn't answer that.
What is the basis? Let's say when we consider this ordinance, if we put a microcell towers in the white area, giving the range, they would cover most of the city.
That's staff's assertion, and that is why we chose the distances that we did.
What's the assumption of the range you use?
We used, so AT&T at this point has been proposing facilities approximately 1,000 feet apart. They vary from maybe 900 to 12 or 1,500 feet apart. So that's not saying that's what the range is, and I think it varies broadly depending on who the carrier is and what their standard equipment is and the power of their radios. It also is going to be affected by topography and potentially a number of other factors that I couldn't necessarily speak to.
They can simply increase the power, therefore increase the range.
That's a possibility in some instances.
Okay. All right, thank you.
Chris. Hi, Katie. Can you go back to that conclusions slide you had, please? I just want to get some clarification. On the second line item, city cannot base location standards or separation requirements based on RF. What do you mean by that?
That means that our ordinance, as we're discussing separation requirements in our ordinance, we should be basing them on aesthetic concerns, which we talked about significantly just a few minutes ago. We cannot base them on RF because the RF exposure varies
So
depending.
it's RF exposure, not necessarily the coverage.
That's correct, yes.
Okay. Because the last item, decide what is an acceptable level of service or acceptable type of service.
Yes.
Are we going to be requiring them, AT&T and Verizon and the carriers, to submit coverage maps?
These are things that, yes, we're going to ask for in our application. But what we cannot do is say, well, we think that that is an acceptable level of coverage. If they say they need more signal densification and they can show that to us in some way, then we don't get to decide, well, we don't need faster data speeds, for example. That is simply not a local issue.
How do you resolve that with effectively prohibiting, or in the Ninth Circuit, as Andrew pointed out, significant gaps? So as long as there's not a significant gap, we could do that, right? We can set these.
So that's a difficult question to answer. It is difficult to resolve, and these are the types of things we'll have to weigh as we're evaluating these applications within 60 or 90 days.
And that gets me to the application. So in the ordinance, it says application content. The things that are submitted may be changed by the city planner at any time, correct?
That's correct.
And none of them are required necessarily, as long as the city planner decides that the information that he has is sufficient to make a decision, correct?
That's the way the ordinance is currently drafted.
So there's nothing specific that the carrier is required to submit?
There is. The carrier would be required to submit what is on our application at any given time.
But-
If we find that we need additional information to be making these decisions, the city planner can simply add it to that application.
But the line items on the application itself, they may be on there, but the carrier isn't required to submit all of them for a decision, correct?
No, they would be. That would be part of the completeness determination,
And how is that supported by the ordinance?
because the ordinance says that they have to submit all of the application requirements.
From a legal perspective, David, do they have to be spelled out in the ordinance?
Like Katie said, as long as the ordinance authorizes, the department or a member of the city staff or someone in the city to issue an application form that kind of articulates all of the requirements that the applicant has to meet, then that's fine. And that's an approach we've taken in quite a few cities.
And if I may tag that with, speaking as not the wireless special counsel here tonight, thinking more broadly about the way other applications work in the planning realm, it's actually a more familiar means of requiring application information. Oftentimes there'll be a list of requirements, and the last one will be as otherwise required by the planning office. So this is actually consistent with general practice in the ordinance, the zoning ordinance at large.
All right, thank you.
Okay. Don?
Yeah, question for Katie and then the lawyers. I think you used the GIS system to analyze and arrive some consensus on the distances required here, like 100 feet, 300 feet, 500 feet. So you use the available technology we have to try to help base your decisions along with engineering and everybody else on the distances required. Is that correct?
That's correct.
Okay, so now for the lawyers, come on up. So using a GIS system to try to do a best faith estimate using data, using topography and what the terrain deals with us to us here, is that a reasonable and defensible approach to take for determination of distances?
Well, I certainly think it's, in all the ways that you could go about it, I think it's a reasonable or valuable way, and I've seen cities use to visually present what a certain restriction will actually be like in practice, like you said, the actual application. Defensible, I don't think necessarily, I don't know that the method through which you reached a specific design standard would necessarily come into play that much. I suppose perhaps it could come out in if there was some sort of legal challenge, maybe it would at least be a justification for how you came up with it, but I don't think it'd be, more or less, I don't know what we're.
See, some cities have come up with
comparing it to.
500 feet between residents and 1,000 feet from
Right.
schools. I don't know what they use to come up with that
Right.
distance. I think the staff here try to use
Yes.
available technology for geographical information system to try to arrive at a reasonable distance. And so I'm asking you, is that a reasonable approach to take? You're next, get your answer ready.
Sure, I think it's like you said, I think it's a good one. It's certainly one that the city can, if ever asked, can explain and show that I think that they made a good faith effort to try to visualize them, see how it would actually impact installations and also the community aesthetics. There's likely communities out there who don't go through that much effort, and they probably just pick them based off of what they see elsewhere without considering, the actual layout of their communities. And so I think, that certainly is a good approach to take. Whether the specific numbers that they settled on or any, supported any more strongly because they took that approach, hard to say. But I certainly think it's a useful, valuable tool to use in trying to visualize the distances.
Your answers are similar to my lawyer friend Tally here all the time. So.
Only with you, Don.
Okay. All right, BBK. The rationale the staff used was use some technology, to try to balance community input, community concerns, safety, aesthetics, and the way our hands are tied with the dealings from the FCC. So from the BBK perspective, did we use a best-faced effort to try to determine the distances that are presented to us tonight?
Well, if I may, Andrew is one of our best BBK.
I want an answer. I want your answer. I don't want his. I've got his answer.
Right. Well, I agree with everything Andrew said. I'll throw in some additional context. In the planning world, we deal with sensitive receptors quite often, daycares, schools. This comes up in the context often of alcohol uses. There are often things and times where noise is an issue. Sometimes the state or federal statutes, more often state, will provide minimum distance requirements. Other times it's up to the cities to determine distance requirements. And how cities go about in determining those distance requirements is generally up to them, so long as it's not arbitrary. And Andrew laid out how in the case here, in dealing with the wireless installations, it makes sense to use the technology and methods available to staff right now. So within the greater context of efforts to identify distance requirements for sensitive receptors, it certainly falls in line with that. And per Andrew's response, it makes sense specifically in the wireless context.
Thank you. Now, in regards to coverage maps, which I always think were, every macro tower's application that came in the last 10 years I've been on this commission, and Verizon was very good at it, was, you see a was-is. This is what it is, this is what it was, this is what it's going to be. And you could see the public benefit out of a coverage map. There seemed to be a lot of reticence about coverage maps for these microcell sites, and I want to know why there's a reticence about that.
So where this comes into play is the new kind of standard materially inhibit standard that the FCC articulated. So again, under federal law, from the Telecommunications Act, local governments cannot take any actions that prohibit or effectively prohibit the provision of personal wireless services. So that's the federal law not changing, at least for now. So that's where it's at. The Ninth Circuit has interpreted that, and they decided to institute this test. They applied the test. It's 2 steps: significant gap, right? So you first say, is there a significant gap in coverage? And then step 2, if so, is this the least intrusive means of filling that gap? And I think, like you said, that's kind of an easily understood test, right? Like, is there a gap here? Is that significant? That would be a finding of fact, but ultimately, it's a simple test. In the FCC small cell order from 2018, the FCC decided to interpret that federal law and say, determine based on industry feedback and all the comments they got, what, in their own opinion, I suppose, what constitutes an effective prohibition. And they said that rather than it just being based on coverage gaps, they look at whether it's materially inhibiting service. And if some local regulation materially inhibits service, then it's an effective prohibition. And you may say, well, what does materially inhibit? And their point was they essentially said it can involve a whole host of services that they provide. So rather than just saying, is there a gap in coverage? It's saying, is there a coverage gap? Are they trying to densify their network? Are they trying to provide new services? Are they trying to improve existing services? So under the FCC's reading, all of those factors, if you're preventing any of those from happening, you could be materially inhibiting service. If you're applying their interpretation, you would thus be effectively prohibiting service. So it's certainly a much easier standard for the industry to meet, both because it includes a lot.
Their K Street people were very good. In other words.
Well, some may say that that's the case. There is legally, our position would still be to argue that, at least in California, that the Ninth Circuit test would be appropriate, but there's not a definitive answer to that at this point. There's actually cities I've seen who are kind of involved in potential legal challenges. They're currently at the appeals right now, like in the city, and carriers sometimes address both. Like they just address both tests because even the carriers, I think, weren't really sure which way it will go. So that's why sometimes with the small cells, since that's the small cell order bringing this in the right of way, you may not see the coverage maps come up as much because they're trying to apply that new materially inhibit standard. And at that point, it becomes more difficult, like as to what technical data or what visualization of the technical data.
So has the industry come to published any papers, they have to have some rationale, some process that they arrive at this site helps their system out.
Yes.
Because they're making an economic investment here. They're spending money. And there has to be a process that they use that says, this light standard is going to help our system out and provide service to our customers. So where is that process delineated? Why can't they share that with the city of San Clemente and its citizens? And I'll tell you why. One of the cell sites we were looking at, and then we disapproved and put on hold, is right out across the street from a school, an entrance to an HOA, near houses. It's in a bowl. And you looked at the coverage map, you'd say, if I was a stockholder in that company, why would I be putting an antenna site there? It didn't give them any benefit. They actually had a coverage site map available, and it was broadcasting in the side of houses and hills in this little bowl, and wasn't even filling in any gaps or anything. And so they've got to use some economic model rationale and technical model that says, here's where we're putting these sites, and this is where it's going to deliver what we need, that we feel the data and our customers are going to want. What are the tools they use to make that determination, and why can't they share that with us? Why can't our application require them to say, show us the tools you use to determination that site determination?
So they may be better to answer this than I am, but I will give from what I've seen, my best answer. So a couple of things at work. You can still get some information, right? Like you can still request some justification as to the location. I've heard from industry representatives at various meetings or talking after that they argue that the city staff, not here necessarily, just in general, city staff would not necessarily be able to understand the data that they would be provided. That doesn't mean you can't get any. I think there's a potential argument that it's privileged or confidential business information as to why they're making these business decisions. Again, I don't know that for sure. I just think that could be one potential issue, but it is something you could explore.
That's like
how
you're from
to try to
Scotland
address.
wearing a Scottish kilt with no underwear. I mean,
Yeah.
This
So
is like,
you can, at the very least, in the app, there's a couple ways to do it in the application form, but you can ask essentially for a location as to what a location justification, kind of what are some alternative sites, why did you choose this one?
in
It's not
verbiage understandable
yeah.
to the city planner and the community development director.
So.
Or the planning commission, or the public that attends the appeal.
But if
Can
there's
we put that
any-
in our ordinance? Is that okay, you know? Or should the application state that? You know, can we put that on the application, that the applicant will provide data that's understandable to the local public and the city planner as to the rationale for this site location?
Yeah, you can certainly, we would have to figure out a good way to say it, but it would be in the application form, not the ordinance. Which, again, just backtrack to that very quickly, it's helpful to have the app form kept separate, because then you can more easily kind of amend it as you hear from the industry, or you just from the staff through practice, like what's working and what's not. So it would go in there, but it is something, you know, we could figure out a way to kind of request it. It would have to be, it would just have to, I guess, be a little bit of legalese, right, to figure out what's the kind of an objective way
That's why you're
to
standing
say
here,
that.
still working on it, yeah.
So we can, if it's not already captured in the app form, we can try to figure out a way to maybe get a bit more of the data.
Or does it make sense to put part of it in the ordinance, so they know up front? Or is it?
I would say that it's best to keep it in the app form, since it would be an application, if it's meant to be an application requirement, only because they're still completely obligated to go off of that app form. You can issue notices of incompleteness based off of that application form, and so it's good to have it all kind of lumped together.
But
And
would
if
it be appropriate to have a word or two in the ordinance to make sure that that application has the force of law behind it?
So the application is mentioned in the ordinance, in section D.
And I think Katie might want to chime in on this
Sure,
as
yeah,
well.
do you wanna-
So, did you have something?
That's just what I was going to point out. So, first of all, it's not that we don't address application content in the ordinance. In attachment 5A, you'd be looking at page 8B41 of your packet. D, application filing. 2, application content. An applicant shall submit an application on the form approved by the city planner, which may be updated from time to time, but in any event shall require the submission of all required fees, documents, information, and any other materials necessary to allow the city planner to make required findings and ensure that the proposed facility will comply with applicable federal and state law, the city code, and will not endanger the public health, safety, or welfare. If no form has been approved, the applications must contain all information necessary to show that the applicant is entitled to the wireless permit requested, and must specify whether the applicant believes state or federal law requires action on the application within a specified time period. So, and we can ask for a variety of things on our application form, and we are going to. I understand that you don't have that before you today, but we can ask for coverage maps and narrative and any other supporting materials, as are, vaguely referred to here in the ordinance, that would support the location of that facility in any given area.
Thank you.
So, per that, I'm looking at this last bullet point on what the city can't do. If we can't decide what an acceptable level of service or acceptable type of service is, even though we can ask for that information that Don was talking about, could we include it as a variable in our decision to approve or not?
Well, as Andrew was referring to earlier, there's kind of two tests, and I put the more conservative, I would say, approach in the ordinance, at least the more legally conservative approach in the ordinance. And that's what this bullet point is referring to. As Andrew mentioned, here in California, we do have the circuit court decision, and so it could be legally defensible to use the significant gap test still. But Andrew's kind of already spoken to that. So we can definitely ask for all of that material, but in the event that, the coverage maps don't show a significant gap, but the applicant makes some other justification, this is a case where staff would probably ask for BB&K's opinion on, whether a site should be approved or denied based on that information.
Okay, thank you. Bart?
How far could we go with this? This is a legal question. How far can we go asking for things we can't make decisions on? I mean, we're asking for information we really can't base our decision on.
Might not be able to make
Coverage is something totally different than RF. I mean, they can say, hey, this particular tower, we're going to put a little circle around, so it shows a gap, but we can't ask what the RF ranges of that tower, can we?
So you can confirm that the facility, both at the application stage and post-installation testing, complies with the applicable FCC regulations for radio frequency emissions. So you're not completely in the dark. It's just you can't regulate based on what the effects of those emissions may be, as long as they meet the FCC standards. Now, if they didn't meet the FCC regulations, then you can certainly regulate based on the effects. So you are allowed to at least verify that. So the way the form we initially kind of sent to the city, and I think what they've worked off of was our firm's like attempt to kind of just compile everything that we thought local governments may want, and then they kind of tweak it depending on their own needs. Some want more detail, some want less detail, but all the information that they thought would be helpful in making a decision. If you look at the findings, which are in section G, which is on page 8B 42, you'll see that they're I would say relatively general, and that's to help, because each application is unique, right? But it does give the city planner does have clear findings to go off of, and I think all that information would factor in. So in trying to determine, if it meets the applicable design development standards, you need a lot of site plans and siting information for that. And if you just kind of go through the list, I do think that the information that the city is requesting will be valuable, and I feel certain that if it wasn't in any way relevant, the carriers would probably push back and complain, and perhaps you would see that, but I think most of it is, or all of it is stuff that the city would want or can ask for at the very least.
Jason?
Yeah, so I guess I want to walk down the road of administrative law for just a second, because the substantial burden test that was adopted by the Ninth Circuit, was done, about 20 years ago, something like that, 15 years ago. It was done some time ago, right? And there's been several declaratory rulings by the FCC since then, and rescission of rules that were relied upon in that test, even though they were interpreted in TCA, right? How does that impact our view of this, right? Because these rules, the one that we're dealing with right now, the 2018 rule, right? The order that came out for the declaratory ruling by the commission, and then now, obviously, the 2019 stuff that's pending, it's published anyway in the Federal Register. That would seem, on its face, to repudiate the holdings that were made in the different circuits and try to realign those with new regulatory rules that they've put forward. So are we just going to proceed on the dual track that maybe the Ninth Circuit holding is still valid, even though those rules have been rescinded and replaced?
Yeah, so
Fun stuff.
yes, we are, okay. A couple of things. I'm not sure on with regard to, the substantial burden or substantial evidence, maybe I'm misunderstanding, but the context that came to mind in terms of where we see it in wireless law is denials, right, have to be based on substantial evidence. And so
I think it's the Metro PCS.
that's something we stress, right, like when it comes time to hear applications and stuff, that comes up a lot. In terms of going down the road without knowing which test applies, I mean, to some extent, yes, because the FCC also put out the moratorium order in 2018 saying local governments cannot issue a moratorium on wireless applications. So, it did not put local governments in a great spot, because you can't just say, we're going to wait and we're going to see how the litigation involving the 2018 small cell order, how that turns out. We're going to see once courts start interpreting this. Unfortunately, the cities don't have that luxury, and so it's our opinion that you could make a good legal argument to apply the significant gap test, but as a court hasn't told, no court has decided that yet, at least not here, that it is a bit unclear, but you do kind of have to go down that road because the FCC put you in that position.
Well, and so, I mean, I think if they were building a macro site, you could still apply that standard without question, right? Because this didn't supersede, I mean, the 2019 stuff that came out last week.
Well,
But I guess my concern with the requirement of the coverage maps is, my understanding is we have to have an objective standard. And how can we have an objective standard other than, yes, they need it or no, they don't, based upon what they determine that they need, right? Because we aren't, spectral engineers, and we don't understand, they may have plenty of signal, but no throughput, right? I mean, we've all seen that happen, and, as things are becoming more automated, you need data to traverse it, even if you've got a signal.
Right.
So how does Gabriel or Cecilia or staff determine what's good and what's not good?
So that's why, that's where I think they would just have to rely on the findings that are laid out in the ordinance. So I think if anything, that would be the place to really, if you feel there needs to be some sort of more detail or something, that would be the place to go. In terms of like, I guess, if they're asking for a justification on, whether a site is needed, I think it just would have to base it off of what we get from the application materials. And I think in light of these comments, we can go back with the city staff and look at the most updated version of the form and see if there's a way to perhaps obtain more. And then in terms of them interpreting that data.
How do you make it objective, right? So if you ask them for something, how do you make it objective, right? I mean, that's the thing that concerns me. We may get the data, but how do you make it objective for staff to decide whether it's necessary or not? Or just the mere fact that they're applying for it, is that the objective standard that it's necessary in their mind?
I mean, I think, obviously, yeah, them applying for it, at least to the carrier, they would argue that it is necessary. And then depending on, I guess, which standard, like, for example, if you're doing the significant gap test, let's just say, I think if you're going off the coverage maps, it's clear that a gap could exist or not. You can kind of see it. Whether that is a significant gap becomes a question for the approving the reviewing authority to decide.
But what gap are we talking about, right? Because when Metro PCS came out, the gap was signal.
If we're going with the gap test, right?
But it was signal, and we're talking about different types of gaps today.
Or densifying network, which comes in, right? So.
Well, yeah, I mean, you may have a signal, but you may not have service.
Sure.
Right. So I guess I'm concerned with.
Up, yeah.
Yeah, I mean, and that's a concern. So the more we go down that rabbit hole, the more concerned I am that we find ourselves not being objective.
Well, practically speaking, getting back to how it'll be implemented, the reviewing authority, so depending on what stage it's at, if there's an appeal or not, right? City planner, community development director. There's 5 findings listed out in G1A, and those findings themselves, I think, are objective. And if it meets those, then
okay.
Right, like that. I do understand what you're saying, and I know the balance that they have to try to strike.
I want to make sure if we adopt an ordinance that it can withstand scrutiny. Because we're going through a lot of work to do that, right?
And I will say that in terms of findings we've kind of used in other cities with whom we work, these are probably even more, I think, more detailed than the staff did a good job of kind of breaking them out and addressing concerns that I think have come up in the various meetings. So it's certainly not out of left field, and if anything, they do kind of articulate a little more detail as to what the reviewing authority would have to find.
Thank you.
Okay, Mike?
Yes, thank you. Okay, Andrew, question just to re-examine the prohibition component. When we're hearing from the other side, so the applicant side, that there would be a potential prohibition caused by X amount of feet separation from a sensitive use. And if that's been codified, we've got 200, 100, whatever it is, and the applicant says, well, it doesn't work for us, we're going to call that a prohibition, but we have an exceptions remedy. Does that eliminate or relieve that prohibition if there is an exception that can be met?
So it can. It can be kind of a safety valve. I say it can because there's two main possible ways that you could face a legal challenge to, let's say, a specific design standard, 200-foot separation. It could either be a facial challenge, meaning on its face, just regardless of which specific installation this design standard was applied to, it is unlawful, right? That's the facial challenge right up front. Another challenge could be an as-applied challenge, meaning it's not inherently unlawful, but the manner in which the city applied it in this very specific instance was unlawful. So let's say it's the latter. If this instance may have been an as-applied challenge, like they waited until you literally denied it, and maybe Gabriel said, oh, this doesn't comply, denies it, and then it gets appealed, denied again, and they challenge it based off of that application. Well, sorry, it would be before it gets legally challenged, but that exception process would kind of give you an out. You would say, okay, in this instance, the way it's being applied, we agree that it would be an effective prohibition, we'll grant you an exception, right? If that happened, you would most likely end up being clear that this is not setting a precedent, it is based on the very specific aesthetics and situation facts in that one-time situation. If there's a facial challenge, I mean, the exception process could help kind of give you an out, but more because I think both to show that it's hard to argue there's an effective prohibition if there is a way for them to kind of get around it, right? Like if they show you there's an effective prohibition and you're giving them an out. More practically speaking, it could also come up in the context of if you're going to issue the exception, then they're probably not going to sue because they don't care at that point. But there is certainly a risk that you could get a facial challenge on various designs. You know, it just depends. Not anything particular here, just conceptually. You could get challenged right up front, and you would try to rely on the exception process. But I know from industry feedback, not necessarily in practice, but just what I've heard at meetings, they appreciate the exception process being a thing, but they don't want the city to solely rely on it, like any given city, not just San Clemente. And so it's trying to strike a balance, and I think that's what staff tried to do, is not just go where they're going to be very, very, very restrictive and just have to constantly issue exceptions. Try to get to the middle where you think they're reasonable, but if the carrier can show there's some sort of good legal argument for issuing that exception to prevent a violation of law, then they can issue it.
Okay, do you think it would be reasonable to take a minute, take a little bit of time to do some real research, maybe have a third-party expert come in and demonstrate what, across the board with all the carriers and their operable frequencies, what their effective distance would be? Because, we're putting arbitrary numbers on things. So if it's 300, 1,000 feet, that requires an extra step for the applicant and the burden on the applicant to demonstrate why that would be too much, and their service objective is now in question in terms of meeting that objective due to that distance. But if we had some, and we've already talked about it during this meeting, we have really nothing to rely on but the applicant's information, simply saying we have to have it. But we don't have a third party testing that. And a step further would be to have some criteria. Would it be reasonable for the city to have some baseline criteria in terms of reach of that particular frequency and that particular equipment, even on maximum, turned all the way up? What would be the reach of that equipment? That would give us a parameter to measure distance and what is reasonable. And that would be the argument for what is reasonable and what is not.
Let me step in here for just a moment. Clearly, we've been drilling down pretty deeply into some of the legal things. It's a kind of a very detailed question. If it's all right with you, we'll finish up with Chris for the questions and open up public comment, and then handle this during discussion when we get to that page. Is that all right?
But I will need a response from legal on that in terms of reasonable.
Yeah, when we get to that.
Okay.
Yeah, when we get to that part of the ordinance,
Okay.
by all means.
Excellent.
So, yeah.
Mr. Chair,
I'd be open to that.
could we take a 5-minute break after Mr. Kaczynski?
Okay, sure. Chris?
All right, thank you. I don't mean to beat a dead horse here, but I just want to walk through this, just so I have a clear line of thinking. I'm going to put on my lawyer hat here. Time, place, and manner effectively prohibit. If they were going to sue, who has the burden of proof that that the city effectively has prohibited them from the wireless service?
So if they're suing, the burden would initially be on the applicant suing the city,
So it would be
saying
on-
they violated federal law.
So the carrier has to have an objective, or provide objective data, facts that show that they've effectively been prohibited from the wireless service.
Yeah. And
It's not the city's burden.
that burden is also kind of worked, so that's from a legal perspective, but it's also worked into the ordinance itself, saying for exceptions, which is essentially where they're kind of making that
Right,
initial
but
argument.
initially,
The burden's on the applicant there as
The
well.
burden is on the carrier to show, this is our data, this is our facts, we've been affected. So those facts, when they compile those facts, they can provide those facts to the city during an application process, correct?
Yeah.
And second, if we do, rely on the significant gap from the Ninth Circuit, that's our circuit. So if there's a legal challenge, it'll go to the Ninth Circuit. So whatever they decide, we're not going to be in front of the Second Circuit or the First Circuit. The only decision that's going to overturn the significant gap or Ninth Circuit is going to be the Supreme Court, correct?
Yeah, I don't know if it got up to them. I guess there's a chance perhaps the Ninth Circuit will speak on this in hearing the order. I don't know, obviously, but.
So that last bullet point item is very conservative. It takes a national approach, all the circuits, correct? Decide what the city cannot do. On the right.
This one?
Yeah.
Oh,
Because under the Ninth Circuit,
so I don't want to speak for Katie, but I think what she was getting at is just saying that you can't perhaps restrict, I guess it was the uncertainty we had discussed with the significant gap in the
so from what
materially inhibit standard. So anyway, sorry, yeah, so I don't, but it's not a clear-cut answer. Like if, let's say, we got something of the city's got challenged and we end up in a state court. It's unclear what they would choose to apply. Like, I know what we would argue in the legal brief,
Right.
But it really is not.
But the lower courts would follow the Ninth Circuit, which is our circuit. When,
I don't know. They might. Judges
but
kind
in
of
any
just
event- in any event-
I think the industry would probably argue that the FCC's interpretation should be applied, and then we would have our legal position as to why that is not necessarily the case. And that would probably be really helpful to a whole host of cities to
but
see
at the very
what
least,
judge
the
says.
applicant would be required, would hold the burden of proof to come to court with a stack of evidence.
Yes.
Documents to show we've effectively prohibited the wireless service.
Yes.
That information should be available during an application process.
How to obtain that, yeah.
Yeah, okay.
The key, and I think this could involve more potentially, just getting more industry feedback, is to figure out a clear way, right, to sticking with the objective standards and requests, and a good, clear way to request that information from them. So I know we already talked about it a bit in the form, but we can speak with them a bit more as to, how to word what that is, not just like, give us all of your kind of reasons for doing, like, we have to kind of lay it out, both so they know what the city wants, and also so that city staff has a way to verify that an application is or is not complete. So we can certainly talk to them and elicit more feedback.
Okay, we're going to take a brief break, 5 minutes. We'll reconvene at 20 of. call the Planning Commission back to order, and we will open the public hearing. I have a number of cards. I'll call out your name, and when I call out your name, please come right up to the podium. I'll actually have a little line of 1 or 2 people so that we can move through this with alacrity, and then when it's your turn to speak, you can step right up to the podium. So I have Jeff Perkin and then Courtney Morrow.
Hello, Planning Commission. Should I begin?
Please.
Okay. So the elephant in the room, as usual, is what we're not allowed to talk about, what is not considered legal, and where your hands are quote-unquote tied. The public has been reminded repeatedly throughout this process that, quote, by law, separation distances cannot be based upon concerns related to RF exposure and health. I still can't fathom how this can be acceptable to you or anyone who cares about protecting their own or others' freedom and health. We must not consent to this insane breach of power. FCC guidelines are cited repeatedly by officials and engineers as an assurance of safety. About this, Dr. Sharon Goldberg states, quote, the FCC guidelines are not relevant to chronic daily exposure that we see in our country. They only apply to exposures that are 30 minutes or less, so it's for a short-term exposure. They were developed by engineers and mostly people from industry and the military. Physicians and people with public training were not consulted. Really, no one is looking out for our health in a regulatory manner. There's no regulation because the guidelines are simply too high, end quote. The 100-foot distance established in the ordinance as it is drafted now from homes is unacceptable, and it was only decided upon because that distance makes it possible for these companies to be allowed to do business near our homes where we are most vulnerable. And to address the question of why it's still 500 feet for children at schools is because we have hearts and souls, and we're trying our best to not address the elephant in the room. But in a recent study found on the U.S. National Library of Medicine at PubMed.gov, researchers examined abnormalities in blood samples in people living at different distances from cell towers. They identified a significant increase in blood cell damage in those living within approximately 250 feet of a cell tower versus those living greater than approximately 950 feet from cell towers. They found indicators of genotoxicity, chromosomal abnormalities, free radical formation, and cell membrane damage. This is one of many peer-reviewed scientific studies posted on websites like mdsafetech.org, which is run by a coalition of doctors called Physicians for Safe Technology. The bottom line is that microwave radiation interferes with the normal function of our bodies. And placing these at 150 feet is pointless if this scientific study shows that within 250 feet there's these significant health impacts that we're not allowed to consider, which is keeping a lot of these moms up at night, and it should be keeping you guys up at night too. We have to really consider the moral impacts, even if the FCC, a captured agency, doesn't want to allow us to. Thank you.
Thank you. And let me mention 2 things real quickly, just in response to something you said. While we may have restrictions in terms of what we can consider for the ordinance or for the applications, you have a First Amendment right to address us about anything you think is relevant for this, so you don't have any such restrictions when you're addressing us. So I just wanted to make sure everyone was clear on that. So I did want to mention, I should have mentioned before we spoke, that we did get over probably a total of 60 or so pages worth of public comment, and you can certainly trust that we've read all of that. I was reading them up until about I think 4:30 or 5 o'clock today. So so we have seen those. You can speak to them if you wish, but you can also be sure that we have looked at those. So next we have Courtney Morrow, and after Courtney Morrow is Kristen Fuller.
All right, good evening. First, I want to thank Commissioner Wu, Commissioner Kaczynski, and Commissioner Brown for your pointed questions. This is what we've been looking for, is to actually push back on industry, ask questions that are in the interest of residents. For the commissioners that clearly have a conflict of interest and who have failed to recuse themselves from this topic, Blackwell and Talley, shame on you, really. I want to talk about there is an EU-funded review body dedicated to policy that may impact biodiversity in the ecosystem. And they looked at over 97 studies on how electromagnetic radiation may affect the environment. Since clearly we're not getting anywhere on public health and safety, perhaps we can talk about environment, considering the FCC just lost in a ruling with regards to trying to fight exemptions with NEPA. We can look at this from an environmental standpoint. And there's plenty of studies that show the potential risk to birds, to insects, to plant health. I don't know about you, but I would like a planet to live on that has some flora and fauna. Otherwise, we're no longer existing. I also think it's become abundantly clear that our city staff is particularly friendly to wireless industry and their egregious deployment of unsightly towers all over our town, and most concentrated in our parks where our children play on a macro level is quite disturbing. We need to really look at CEQA. I know I've read the reports that Katie has put together, and using a Class 3 exemption is just not right. One of the exceptions to CEQA says that all exemptions for these classes are inapplicable when the cumulative impact of successive projects of the same type in the same place over time is significant. Look at where they're wanting to put these. These are just in the reserve community. They want 5 towers all within one area. That is a cumulative impact, and that is significant. Ask yourself, why are so many people in every other town fighting these small wireless facilities? Ask yourself, what would be a safe distance for your own home when you see these outside your bedroom window or when you walk out your front door? If we're just looking at aesthetics alone, these things are hideous. Is this what you want to see outside of your house or every 200 feet? It's easy. And here's a suggestion. Go home and sit in front of your wireless router for an hour and see how you feel. Do you feel a headache? Does your heart start pounding in your chest? And then now significantly multiply that 24 hours a day, 7 days a week, and tell me that that's not going to have an impact on health. I know you can't make that determination, but those are being challenged in the court. And we need to wake up and try and to do our best to protect citizens. Thank you so much.
Thank you. And I'll remind everyone here, please agree or not, please allow the speakers to speak without interruption, since this is their time. Next, we've got Kristen Fuller, and then Anne Marie Hines.
Okay. Before I start, in the spirit of the holiday, I'd like to pass around some Trader Joe's JoJo cookies, so we can maybe take the edge off with a little sugar. All right. Everyone loves cookies, even if we disagree on a few things, right? All right. Hello, City Planning Commission and Planning Department. Thank you for your attention and listening to our group of concerned and educated parents and city residents. We all acknowledge that there are important aspects to be considered in light of the small cell ordinances. I'm not a telecom expert, city zoning expert, legal expert, but I feel very strongly on this issue. We believe that very similar to high voltage electrical power lines or the building of a toll road or highway near a residential area, multiple small cell sites in close proximity to homes and neighborhoods will have the following negative effects: potential and real impact on the health and safety of nearby residents, the degradation of our ocean, mountain, and hill views, the significant implications on future perceived and actual home values, and interestingly enough, on the residential street adjacent to the Veracruz site that's being in appeal, is Camino Oleada in the Reserve East. Both a firefighter and an AT&T employee have listed and or sold their homes in the past few months. So I think that seems like kind of an odd coincidence. While most of us agree there's a need for better 4G coverage in certain parts of town and a valid reason for improving those less than optimal cell coverage zones, the procedure for processing these applications needs to be on the side of the people and their concerns and priorities. The City Planning Commission and the City Council needs to approve a small cell ordinance that has a reasonable balance of all parties involved. Ideally, this ordinance would be applied to macro tower and antenna applications as well. So this would be at least 100-foot or more setbacks from property lines, 500-foot setbacks like we discussed from schools, and ideally 500 to 1,000 feet or more distance between poles would be at least a starting point. Annual independent third-party RF testing of cumulative RF load is ideal, and the expert that you brought in at one of the other meetings even spoke to that effect. Transparency to the public by adequate noticing of applications, allowing public input and informing residents of current and proposed placement of both macro antenna and small cell sites through maps. An up-to-date list on the website would be helpful. An updated wireless master plan should be established before any pending or future approvals are made. We understand that telecom carriers can and probably will apply for exemptions to the ordinance on occasion, but let's require them to do their due diligence, show real coverage or business requirement, and make them find the best proposed sites to meet their goals, while keeping our small villages by the sea just that, not a small village littered with small cell sites on every street corner and cell towers in and around every neighborhood and park. Let's do the right thing and set the bar high out of concern for our fellow San Clemente residents. Let's emulate other progressive towns like Encinitas, Palos Verdes, and Laguna Beach that are being thoughtful and concerted in their efforts on small cell issues. Let's pass a fair and balanced small cell site ordinance with which we can all feel confident and comfortable. Thank you for your time.
Thank you. Next, we have Anne Marie Hines, and then Renee Plasky.
Well, you're celebrating with some Christmas cheer. I want to start by wishing everyone a Merry Christmas. Also, our group, not as large as we had hoped tonight, represents this entire city of over 70,000 people. And I know for a fact many wanted to be here but couldn't be here tonight because they were contacting and emailing me because they had Christmas celebrations this week. This map of San Clemente scares me. It scares me because my house is on this map. And you speak so casually about the 100 feet, 200 feet, 300 feet, 500 feet, and 1,000 feet. I've looked over this map multiple times, and they all look pretty much the same to me, okay? The parks, the schools, the residences, and I think even the businesses should be protected from 5G, which is 10 times more powerful than 4G. My information comes from Arthur Furstenberg. 5G is a phased array. Instead of being covered in a 4G blanket, 5G will send out 1 million powerful concentrated beams whizzing by us all the time. These phased arrays will concentrate their energy into narrow, steerable, high-power beams. If you walk between someone's phone and base station, both beams will go right through your own body. The base stations will be located on the sidewalk, mounted on top of utility poles that we all pay for. I've seen this in Laguna Beach. I don't think they have 5G, but I've seen lines of 4G cell towers throughout Laguna Canyon, and it was ugly. The 5G beams are aimed at their targets. The 30,000 watt beams will be merciless to insects, birds, bees, and humans. And like Courtney says, I want to see flora and fauna. The human brain does not have pain receptors and does not feel injury. Over time, the FCC continues to change its safety numbers. Their standards can't be trusted. One of us is right and one is wrong. There will be harm done if one is wrong. My teenage son, sitting in this room, said that all things eventually correct themselves to become right. I agree, but after how many years? So let's be proactive and be very careful in passing this ordinance. Thank you very much.
Thank you. We have Renee Pulaski, and then Bill Kruttinger.
Hello, thanks for your time. I'm EHS sensitive. Being here is hard. My heart's beating out of my chest right now. We're in a room that's moderate to high from my meter. I don't know if I can live in San Clemente anymore. It's for my husband and I to decide. I'm going to read you something from An Electronic Silent Spring by Katie Singer. The electronic technologies that we now depend on may well put life as we know it at risk. What would Rachel Carson suggest? In concluding Silent Spring, Carson observed that those who manufactured and used pesticides possessed no humility before the vast forces with which they tamper. Does our species' survival depend on humbling ourselves? Could we admit how much we do not understand about the things we've depended on since birth? How much we've taken electricity, appliances, electronics, and telecommunications for granted? Could we recognize that our technological advances harm our health and wildlife health? Could we each acknowledge our own electronic footprints? The longer any individual, family, community, or country ignores the dangers of radiation emitted by electronic and wireless devices, the more severe the consequences. What we do need to achieve is a constructive discussion. Can we have that? What actions will reduce our emissions of and exposure to electromagnetic radiation? What will keep us in discussion so that the coming spring is not silent? Thank you for your time.
Thank you. Bill Kruttinger, and then Christine Newhousen.
Good evening, Planning Commission. I'm probably the only guy who comes up and talks about RF who's not really afraid of it here. And I'm in the local radio club. A lot of the questions that you guys have are very reasonable scientific questions. And there are people in the community that are capable of answering them. Propagation maps can be put together using free software. There's a lot that can be done. And I urge you to just reach out to the local radio clubs, and people will be happy to help. I did run the numbers on the 100-foot distance, the propagation loss numbers. I think that the ordinance that you have today is reasonable, and if it's implemented, it shouldn't. I don't expect that you're going to have legal problems. I'm not a lawyer, obviously, but just looking at those numbers, you should be able to get a signal from anywhere that they're allowed to be to anywhere where they need to be, with very few exceptions needed. So I guess I'm just here to urge you to hold the line. I think you have a reasonable ordinance in front of you, and good job. Thank you.
Thank you. Christy Newhousen, and then Tiffany Johansson.
Good evening. I believe it is not a reasonable ordinance that we have in front of us here. An example of a distance of 100 feet from a home would be about the length of a basketball court. Basketball court is about 98 feet. Do you really want one of these unsightly and unsafe small cells that close to your home? Because many residents living in San Clemente do not. I sent an email to the board this morning with a picture of a small cell here in San Clemente that has another cell company co-locating on the pole. If we can only base our decision off of aesthetics, then why on earth would you vote for this to be allowed only 100 feet from homes? And yes, it is possible the connection will work if more than 100 feet from a home. For example, Encinitas has a 500-foot ordinance, and it's working for them just fine. The email I sent had a picture of the small cell, and on the pole there is a sign that sits about a foot above my head with the radiation symbol. It read, quote, "Beyond this point, radio frequency fields at this site may exceed FCC rules for human exposure," end quote. I have a problem with that. Exactly what amount of RF will be exceeded in that sign? Again, this is another reason why we need to push these small cells further than only 100 feet from homes. At the August 21st Planning Commission, I was here at the end of the meeting in regards to how the AT&T chose, how they choose a location where to put these small cells. Frank was asked this question, and he's sitting here at the very end of the row. And he had a hard time answering this question, so he was asked, how many days does AT&T typically take to choose a location? And he said 2 days. So, I mean, is it just blindfolded? Okay, we'll just choose this spot. Within minutes of 2 days, it doesn't make any sense to me. If you want to watch the tape on August 21st, go ahead. It was at the end of the meeting. We are a small beach town that will never look the same with all these obnoxious small cell towers all over our city. We already approved 5 small cells, so why then are you afraid what AT&T might do? Or other cell phone companies? Is this what it has come to, letting these cell phone companies dictate our decision-making and what's best for the people that live here? Mrs. Crockett, I mean no disrespect, but you are not a resident of St. Clemente. Therefore, you don't have the same mindset emotionally that the residents do. Whatever decision is made will not apply to you or your family at all. And Mr. Blackwell, the fact that you work for a cell phone company and have not recused yourself is unfair or just. You have heard myself and others speak about the cancer cluster of 5 children in Ripon, California, which was likely due to the cell tower on school grounds. And there has been another cancer cluster in Mount Greenwood, Illinois, outside of Chicago. 5 children at that school with a cell tower on top of the school. So Ripon had one in the school playground area. Mount Greenwood had one on top of the school. And within 4 years, those children were diagnosed with cancer. I also called to confirm the school, and this is indeed true.
Thank you.
The last sentence, if you don't mind. The beauty of St. Clemente and the protection of the residents that live in it are in your hands. Please vote for a greater distance than 100 feet. Thank you.
Thank you. Tiffany Johansson, and then Michael Farrer. I apologize if I mispronounced that.
Okay. Good evening. I think tonight a lot of us are feeling extremely defeated and disappointed with the proposed ordinance. And I heard Katie say that they started higher, but the only thing that we've ever heard has always been 100 feet. It was never 500, it was never 300. The proposed has always been 100 feet. And you can look through the tapes and see that whenever she came up with this ordinance, it was never starting up here, it was always down here. And I think that we have a big issue with that, because then there's these exemptions that come through. So essentially we're just, hey, free reign, go ahead and do this. And it's a joke, it's not protecting us. You said that you received 60 pages of emails. And did you just read them, or are we going to actually implement some of the feelings of the community into this ordinance? Because I can guarantee you no one said there, hey, 100 feet sounds great. Thank you so much for your due diligence. That's not what anyone has said, and that's not how anyone feels. We're talking about aesthetics. Within 200 feet, we could have 2 mini cell towers. I would love to see, instead of just like a little blob on a map, what that truly looks like, to see a tower here and then 200 feet down, a tower here, and how we could think that aesthetically that's going to look good in our community. Encinitas, we've talked a lot about Encinitas last meeting. This meeting, 500 from schools, 500 from homes. I think that that is a great compromise, and I feel like that is compromising. And if a little more research and things were done, I feel like we could make that happen. We also feel like it would be more fair if you guys posted receipts of any applications that were provided to you for the small towers, so that all residents could see where these are going to go and not just get a notification in the mail. Palo Alto, who is very tech-friendly, they still allow the residents to have a voice, and they are allowed to come to city council and voice their concerns. So I don't know why we're giving away that right. I don't think that that is fair. It hasn't been talked about or addressed, but these towers are all set up to go from 4G to 5G. So what's the plan there if they decide one day to turn it on? Like, how are we notified? How are things changed? Because that changes everything, 4G to 5G. Do your we've been told there's no set rules, so let's go ahead and put a decent ordinance in place. We need you guys to think logically, think about your families, think about our community. What does this mean for us? And please vote so that we can have ordinances where we feel safe and that we aesthetically still have a beautiful community. Thank you.
Thank you. And Michael Farrer. Did I pronounce that correctly?
Good evening. It's Farrer, but
Farrer. I
you
beg your
won't be the
pardon.
last, or are you the first to mispronounce it? I'm with Verizon Wireless. I did make some comments at the last hearing. I don't believe this commission was fully constituted at that time, so forgive me if I repeat some of my comments. First and foremost, I would be remiss if I did not recognize staff's efforts in this undertaking. This is, as acknowledged, a highly technical and highly regulated area. This is a sticky wicket to try to navigate through. And I think Katie has done yeoman's work. She has engaged industry, she has engaged the public, and really bent over backwards to make sure that she took into account all of our perspectives. In addition, I would also recognize and acknowledge this commission's probing questions, probing and thoughtful questions this evening. So to answer, just to point to some of the comments about siting, I know that's a very common topic about why we put things where they are. Over 57% of homes are now wireless only. They do not have landlines. 80%, over 80% of 911 calls originated from a mobile device last year. In addition, the average home now has approximately 13 connected devices. All of these things are increasingly putting demands on the existing wireless network as it currently is engineered. Without the advent of small cells, which by design are lower powered, not 10 times more powerful, they are considerably lower powered than macro sites. Therefore, they must be closer to the endpoint user. And that's the design, that's the engineering behind these things, is that they offload some of the demand on the existing network infrastructure as it currently exists. It allows for the current level of service to be maintained. It's not a static thing. This is a fluid thing, it's dynamic. It continues, the increasing demands upon our network will continue to burden it, and it will continue to degrade. As some of the commissioners have noted, you may have service, but you have nothing going through it. There's no throughput. There's no data coming through back and forth because it's just not, it's clogged. And those sectors, we talked about some coverage maps. It's really more of capacity now. By and large, we have a lot of the coverage covered. It's really a capacity play at this point where we can see demonstrably where our sectors are dying because there are too many users, too many devices connecting to it and putting demand on it. Therefore, they're not working. This is really what the driving force behind the need for small cells. Now, I will say that there are a number of objections noted through our outside counsel. The letter was submitted on the 9th of this month. Notwithstanding, without waiving those, I think we would stick by many of those. I think we can generally work in tandem with your staff to work closely moving forward to try to tweak the existing draft as it's currently written, and I think staff has been very reasonable in their approach.
Thank you. That's the last code I have. Is there anybody else who'd like to speak to this issue? Seeing no one else, I will close the public hearing. There were a couple of questions that I'd like to see if we can address. One is there was a question about 300 or 5, looking at 300 or 500 foot distances as well as 100. Staff did give the Planning Commission maps showing 100, 300, 500, and it was the Planning Commission's feedback that 100 might be the thing to look for in the ordinance because of the coverage issues. There was also a question about implementing some of the email comments, and Katie, I'll have you address that, because I know that you were translating some of those comments into the ordinance.
Yes. So as I mentioned in my presentation, staff did read all of the comments, and we simply can't incorporate all of them. If we did, we would have an immensely contradictory ordinance because the comments from the industry were exact opposite, notwithstanding what a representative from Verizon said here, you'll find in the public comments letters from the legal departments of each of the carriers that have significant concerns with our current draft. And so staff acknowledges that we did disappoint everyone on this. But we were trying to walk the line between, what the industry expects and what the public expects. And the things that are in the ordinance are not arbitrary. They were given a lot of thought. And, if there's a particular thing in the ordinance that you can't understand how we came across it, I'd be happy to explain it. Yeah, we were not able to incorporate all of the comments. That does not mean we did not read them. It does not mean we did not have extensive conversations with various members of the public, and it does not mean that we don't care.
Okay, thank you. There was a comment also about notifying all residents. As I understand, the city has a web page for this. So is that an opportunity that everyone has, and the city has, to see when an application is submitted?
This is something that we could do. In addition to mailing the notices to properties within 300 feet, we could post those to the city's website as well.
Okay, I think that's something that we want to do when we're looking at that. And finally, people wanted to be notified. There was a question about notifying people when someone switches from 4G to 5G. Maybe we could put that up on the website as well when a cell site goes from 4G to 5G. Is that a possibility?
That's a possibility. We could.
Okay, great. Thank you. We're about to enter our discussion. Is there a question?
I just wanted to acknowledge Katie's effort in our briefing here with attachments 2 and 3, where she took a lot of the questions, and in fact published in our briefing book her responses to either industry or the comments, and I thought it was really a commendable effort. I just wanted to acknowledge Katie. You did a great job. It's our attachment 2 and attachment 3 in the book, and I just thought I'd never seen that before in 9 years, and I was very impressed, and I just wanted to make sure that she gets credit for doing a great job.
Yeah, and thanks for bringing that up. I brought that up at the beginning of the meeting for people, and I should say too, I know I've seen many times staff is in the middle of very controversial issues. They have not just 2 parties, but often 3 and 4 and 5 different parties that they're balancing between, and they have legal constraints, and they have the Planning Commission to deal with, and they have the public issues. And it's been my experience consistently that staff works very, very hard to fulfill all of these constraints and demands that they have. So even though sometimes it seems like you're not getting what you are hoping, I can assure you that staff is definitely working hard and keeping your best interest at heart as well. So, are these questions, or can we go into our discussions? You ready, guys? Ready for
discussion?
Okay, good. So, what I'd like to do, we've had a fair amount of discussion already. I'm sorry, did you have something?
I do have a question for staff that it'd be better served if I just ask her now.
Can you do it? Is it?
I guess, sure.
Okay, great. Then, because we have had a lot of discussion and a lot of different sessions, I want to make sure that we're thorough. So, without objection, we'll go and do a page turn of the ordinance, the design standards, and the standard conditions of approval. And that starts on page 8B34. Okay, so starting with page, and that's the beginning of the ordinance, starting with page 8B34. Any questions, comments? 8B35. 8B36. Page 37.
Chair, I do have a comment on the 8B36 regarding the CEQA.
36, okay.
The CEQA paragraph is pretty long, and it starts from a position that the staff believe is not a project, then step back, say alternatively or moreover, et cetera, et cetera. I'm of the opinion that I would consider the ordinance a project. I would support that the project should be exempt So I'm not sure if we need to make a choice in between these two categorization, whether we consider it a project or we consider it not a project.
So I'm, what is it that you're asking? What change are you asking for here? Or question?
The staff laid out two categorization of the ordinance. The first one is this ordinance is not a project within the meaning of a CEQA. And then after a few sentences, it says alternatively, even if the ordinance is a project within the meaning of a CEQA, and the ordinance is exempt.
And so
my opinion is that the ordinance will be considered a project, but I agree with the rest of the argument that this project can be exempt. In other words, if I were to write it, I would have struck the first portion out.
Maybe it sounds like a legal condition here. Maybe you want to address it?
Yeah, Mr. Chair, if I may, it's our legal team's practice when it comes to CEQA exemptions to be as thorough as possible. And so in the event that staff determines that a project is, or I should say an action is not a project, we will also go the next step to say, in the case that someone determines that it is a project, we find that it is exempt. These alternatives occur in many of our ordinances, and so it's our recommendation that we keep in both the finding that it's not a project and the alternative finding that in the case that someone says it is, it's still exempt under CEQA.
Anything else on that page? All right. Page 8B37. Page 38. Page 39. Page 40. A lot of markouts on this page, so nothing?
It's brand new.
Yeah. I actually had a question on this, and it was partly answered earlier, but maybe it's something that we want to communicate to council. My concern here with item 2, this is B2, about the appeal. I had a thought that given there's going to be a whole lot of these out there and people aren't going to have much time to respond in terms of doing an appeal, then maybe it might be appropriate to have a lower fee for the appeal. But that is a bit out of our bailiwick, but we could perhaps send on a recommendation through staff to City Council that they consider lowering the cost of the appeal, if we think that that's an appropriate thing to do and would serve the public. Any feelings about that?
Speaking as somebody that wanted to make an appeal not too long ago, but was dissuaded by the cost, which was twice what it actually was, I would say if City Council is going to lower the cost for an appeal for this, they need to lower the cost for appeals for everything. And this should not be carved out any more or less differently than any other appeal. So if they want to lower the cost of an appeal for a zoning decision or for an interpretation or for something else, which I have no problem with and would support fully, then they need to do that as a blanket across the board and not just specifically for this.
I agree with Commissioner Talley's reasoning here. In one hearing, I heard 2,000. I thought, wow, that's high. But I double-checked, and the staff just told us that it's an administrative appeal at a cost of $501 point something, plus some copy fee, so it add up to $530 something. I think that's reasonable.
Okay. Anything else on page 8B40?
But just to be clear, I would support lowering the appeal fee for everything if we were making a recommendation on
Yeah,
council.
but we're only focused on this particular thing, so. Page 41.
I have a comment.
Please.
Question. So it's D3, and Katie, it's for fees. And we have a post-installation requirement, a post-installation test requirement that's built in here. And where is that fee collected up front? And I'm assuming the applicant pays for that, third-party review?
Yes, the applicant would pay for that as a part of their satisfaction of the condition of approval.
Okay, have we looked into what that costs from a third-party reviewer?
I have not.
Okay, so we're charging a maximum of $500-something per co-location on existing, and $1,000. So our challenge is going to be finding somebody that would review these within that fee structure. Is that correct?
Maybe BB&K wants to jump in on this. I don't know, but my understanding would be it's a condition of approval. In accepting that condition of approval, the applicant accepts the cost that's incurred there. If they wish to appeal the decision, assuming it was appealed, if they wish to appeal and have that condition removed, that option is available to them.
Okay, so it's not necessarily a fee, an application fee, really.
It is not.
It's a cost, just like photo simulations would be, or an
That's the way staff
study,
looks at it.
EMF study, that kind of thing. Okay, that's what I need clarification on. Thank you.
And to follow up on that, Katie, if it was decided by a court or council that you were not going to enforce that condition because of the last week's rulemaking, then that would just be handled at a condition level, not at the ordinance level.
Yeah, the city planner would simply leave it off of the approval and ideally remove it from our list of standard
To be
conditions.
clear, I think it's good that we have RF testing, but I also just want to make sure that it doesn't run the ordinance into trouble.
Anything else on page 41?
I have one.
Yes.
D2. Katie, will we get a chance to see the form with all the questions and required material that the applicant is required to submit?
Yeah, the staff is planning on providing that for the city council, provided this gets passed on to them today. It's not specifically a part of the ordinance. I can see that it's of substantial concern to the decision makers. And so that could be available to the city council. It just hasn't been done, not because I didn't try. I just have limits on time.
Okay.
And per Don's comments on there, I think that information he asked for on the application would be great information to have. My only concern about it is if it would get us into trouble in terms of if we can't use that to decline an application, then maybe we're in trouble if we ask for it. But if we can't, if it's unlikely we're going to get in trouble just for asking for it, and we're not going to decline an application based on that if we're not allowed to, then I think it might be good to have on the application. That's my 2 cents on that. Anything else on page 41? Page 42. Page 43. Page 44. Page 45. Okay, and that ends with then the ordinance section. Our next session is the design and development standards, starting on 8B 46. Does anybody have any questions or comments on page 46? Okay. Page 47. I did have one thing on here. This I don't know if this is for Katie or our attorney. Item 4, in stealthing, we did get a comment from one of the carriers that was objecting to our criteria for stealthing and the design standards for making the shrouds and such look consistent with the rest of the pole. I just wanted to get your opinion. Did you feel like that would be a subjective or objective standard?
If it was the comment I'm thinking of, I believe it was AT&T, I would classify it, whatever they referenced was one of the kind of like statements of general intent. But I think, as we talked about, I think that these are good, these articulate well, kind of the city saying what they feel are stealthing elements. Sometimes cities will literally just kind of put almost the intro paragraph there, like number 4, and not provide the additional details. So here, staff has kind of broken out what they feel constitutes stealthing. And so to take A, because I believe that is the one that was called out, I understand here it's not providing maybe as much detail as they want, but later on it gets to specific, standards for the pole-mounted installations a bit more. And so in and of itself, I could see them maybe try to say like, oh, this is too general, but taken in the context of the standards as a whole, I think it works as an objective standard.
Okay. I was just wondering, what occurred to me there was it could be more objective if we said that they could get the manufacturing criteria of the pole that specifies objective numbers for color and, texture and so many bumps per square inch or however it is that they would describe that. But they have to have objective standards in order to manufacture those poles. So if they would get those, or if we would provide them, that may get into, you were commenting that some cities, they get too detailed. And if we're getting into that problem, I wouldn't want to do that. But it seems like we could come up with an objective standard if they wanted that kind of detail. The question is, do we really need it?
Yeah, I guess you could try to seek out that additional information, but I think, so this gets to, I believe, 4B, is that the one you're looking at? So it's talking about...
yeah, I guess specifically 4B.
The finish of screens and studs. So I think between that, providing the description of matching the color and texture, which I think came up in one of the design reviews, and then if you flipping to the later pages where they kind of get into even more details in terms of sizes and installation locations on the different pole types. I mean, streetlights, utility poles, not like Model X pole. I think together, from what we've seen elsewhere, it would be sufficiently descriptive.
Okay.
Partially because it's hard, as you mentioned, given that there's different models of poles, it could be a bit hard for staff to nail in, to describe a specific color or texture. It's easier to just say match the color and texture of the actual pole it goes on, and I think that narrows it down.
All right, if we capture it, that's fine. And I apologize, I have to go back to page 46 for a moment. I'm looking at section 4A3B. Talks about, let's see, when unmetered service not feasible, the smallest electric meter disconnected to PL shall be used unless placed in an underground vault. Is there any reason why these meters couldn't be undergrounded? I mean, is it necessary to specify an exception?
I think, I guess we don't have to, no, let me rephrase that. Unmetered electric service is permitted by SDG&E for certain powered facilities. There are some, however, that both SDG&E and SCE say, no, you must have a separate meter. And traditionally, we see meter pedestals above ground. Thus far, I've not seen necessarily any reason why they couldn't be placed underground, but that's simply a product of us not having required that before. And so that would be part of the applicant's exception request, should they request this, for why it can't be placed underground.
Okay, so this still requires that they would have to apply to an exception, if they wanted an above-ground meter.
That's correct, because we're saying that, so you can place things in, like the pedestal base, and if you are using the smallest available and it doesn't exceed the size limits that are later in these criteria for whatever that enclosure is, you don't have to place it underground.
Yeah, but that's fine. It'll still be in an enclosure, though.
That's
It'll be
correct.
visible, yeah, so I didn't want any visible meters, and I didn't see any reason to kind of leave the door open to having visible meters.
Okay.
So I guess I kind of say let's strike the condition if people are if that's okay with people, but it sounds like they would have to ask for an exception anyway, so.
If I can add to that, just going over the next page, 8B47, 4A and C, it also touches on equipment above ground. And why couldn't we address it all with a condition that all equipment shall be placed underground except where technically infeasible? So that would be part of the exception too. So anything that's ancillary to the antennas, we would ask that it be placed underground, except in situations where it's technically infeasible for them to do so. If it needs to be above ground, we reduce sidewalk furniture, extra visual elements that may not need to be on the pole.
But I think we were, I was just looking at the utility pole outside my street, and there's, I think, cable service that's on there, and they've got equipment that's placed on the pole. And I don't think we can be more or less restrictive than other utilities that are there. So there's some places where, I'm not talking about street lights, right? The backpacks on the street lights, it's more the backpacks on the old power poles down in Southwest and some other areas.
I think, Katie, don't we get into that when we get to the specific criteria, the difference between the power poles and the street lights?
Yes.
So, yeah, they can't be mounted inside of a power pole. So.
That's the one and only thing we can really discuss or even regulate is the aesthetic component. If there's technical infeasibility, it could fall in the basket of exemption requests,
Yeah, I would even say for the power poles, a lot of that you can still bury, right? Some you might. You can't hide the conduit of the lines going up to the antenna, but you could bury a meter next to a power pole or 5 feet away or something.
Well, power pole, the street lighting is a little different. A lot of thought goes to lighting fixture design, much nicer to look at, and antennas is a completely utilitarian, so they're not a fair comparison.
Well, I think we know we can underground utilities. So,
yeah.
Yes, everything on electric can be underground. It's not inexpensive, though.
Okay. So can we, is there consensus for refining that to change this verbiage to simply require that everything is undergrounded unless it's infeasible?
So
and they would apply for an exception?
It makes sense to me, but I think the city attorney's office
Please.
has something to add.
Yeah, just a quick note. So when it comes to undergrounding, as Commissioner Talley pointed out, there can be concerns in terms of being the requirement that the aesthetic standards be no more burdensome than those applied to other types of infrastructure deployments. So again, if you read that to mean all utility infrastructure, and if you have cable equipment that's not underground, one way it would be more defensible is if it's in an underground district or area where everything is underground, more easily defensible. Also, even if has not previously been underground, but you say, okay, from this point forward, all utilities in this specific area are going to be underground, then that could be more defensible. But if everyone else is allowed to go up on the poles but then wireless carriers only are being required to put everything but the antennas underground, then you are more likely to receive a challenge. So that's part of what was factored in, I think, when kind of discussing it, because it does reduce clutter, but then there are the concerns over equally applying the...
And to further complicate that, Cox has wireless transceivers for Wi-Fi and things like that on some of those poles around town, if you ever see Cox Wi-Fi. So...
is it the radios or the antennas?
Well, but... they're still broadcasting a signal and they're using power that's mounted on a pole and equipment that's on a pole that's visible, that's out there. So it gets dicey.
Okay.
Yeah, I would like, though, with that discussion, to have staff look at, I'm not sure anybody can put new power poles up. They can replace and repair, but I don't think we have any areas where we need new power poles, and we've got areas like the alleys and all that are supposed to be underground at some point in time. They've been talking about it for years, that maybe we do fall within the ability to say, we're not required, this isn't a requirement that we don't require everywhere else.
Yeah, even where there's poles now and they put in a new structure that has to be
Los
underground.
Molinos took the 20D funds for undergrounding, and it'd take about 10 years to get it back up to the same level. San Diego Gas and Electric puts about 2 pennies in every other day on that thing, and so it's that funding is very, very sparse. We sucked it all out.
Oh, I understand that, but I think the requirement is, I don't know where else we'd be putting new power poles.
Yeah.
It just isn't necessary anymore. Repairing them and replacing them, yes. But I think maybe we can comply with what the attorney's saying and make that justification. So I'd like staff to look into that.
But I'm okay looking into that at another night.
Well, I mean, if we're going to approve it,
Well, but that's something that they can do.
oh, yeah, no, we don't have to figure it out, but I think we can say that this A4 or 4A should be reviewed and revised if possible for underground.
Yeah, A and C should apply, in other words, to both light poles and utility poles, because we can't put up utility poles in town anymore. So it would seem, as Bart, that sounds right to me, what Bart's saying is,
Who says we can't?
yeah, what's that?
Do we have an ordinance that prohibits them somewhere? I don't know.
Yeah, when, for instance, when you build a new building, there was, like right across the street from me recently, there was brand new, tore down old buildings, built new buildings, everything is overhead power, but when they put in the new building, power has to go underground to get to the new building.
Really?
So,
Good.
Well, for antenna, I understand, but radio is hardwired to antenna. Why does it need to be on top?
well, that's the point, we can underground that and just
Right.
run a wire to the antenna.
Uh-huh.
Right.
I'm, certainly where there's undergrounding in the city right now, I'm okay with that, but I'm not comfortable with requiring all of this to be undergrounded. I mean, I'd like it, but I think we'll run afoul with that. Certainly.
Well, that's why I want them to look at it.
Yeah, and we have light standards around town where there is no equipment on them. We have decorative light standards. I mean, there are many
Certainly defer to
applications.
council if you can make that happen, by all means, but I think that gets challenged.
And hanging something on the pole isn't what necessarily being undergrounded. I mean, we want to make sure that if we can, all power and all is internal to the pole, not on the pole. We're making that requirement, which means it's coming in from underground. But the antenna is going on the top of it.
A wood pole, you can't get inside that.
No, well, those are existing conditions.
Power company owns the top of the wood pole, that's the high voltage
But you
part of
can-
it.
That would
So
be an
you're going to be
ex-
mid-pole for the wireless.
Yeah, but if you, I mean, that's the
Utility
antenna,
poles,
sure.
absolutely.
But if you're talking about, the radio or the power source, that doesn't have to be on the pole, that can be undergrounded. And if the pole's going to be, if someday, that pole's going to go away anyway, and then we may have a road to undergrounding around utilities.
The reality is-
The other issue, I think, when we had discussions, a lot of these wooden poles, if they want to go on top of them, may not even qualify for putting it on, so they got to replace the pole anyway.
Well, and the reality is, as I'm thinking about it, the wood poles are probably predominantly located within 100 feet of a property line anyway, right? So
Usually
you're
on
going
the
to have an
back property
exception.
line.
that you're
Run
gonna-
down the back of my
Yeah,
property
I mean,
line.
Yeah, so, did staff get that as a potential,
If we
change
can't
here
do it,
for
we
design
can't do it, but
standards?
let's look into it.
Okay.
Just clarify what the potential change would be?
To underground all, to underground wherever possible for utility poles, because we're already doing that for.
Possible or feasible, what
And
was it?
so
Well,
is
sorry.
that-
Technically feasible.
Yeah, where it's
And is-
feasible.
And so is that going to be, is it going to replace just exactly which ones are you going to take out?
I think actually,
see.
we might be jumping ahead, it's probably, Katie, help us.
So I think where it would make the most sense to make this change, because really what you're asking for is already in there. We're just clarifying it for the good of everyone. On page 46, A3B would simply read, "Unmetered electric service shall be used wherever feasible," and simply strike the last sentence there, because on the following page, in the stealthing section, number 4, letter, where did it go? C. It says, "Equipment not mounted to or incorporated into the pole shall be placed underground." But what I'm hearing is that you want C to read, "Equipment other than antennas shall be placed underground."
Where feasible.
We don't even, in my opinion, and obviously
Okay.
legal has not reviewed this, we would not need to list that if we're taking this stand, because Where feasible would say they just have to prove it's not feasible and they don't need an exception. What you are wanting is that they would need to apply for
That's
an
correct.
exception.
Very good.
So then, number 4C would read, equipment, what did I just say? Equipment, yes.
Just equipment shall be placed underground.
Other than antennas. And I will have to consult my research and our attorneys. I don't know about radios, to be perfectly honest. We always see them above ground. That doesn't mean they can't be placed below ground, but the radios are one component I'm just not sure about. So I've noted that proposed change, and we'll report on that to City Council.
I know that I asked that question, I think, in our first workshop with Andrew, and he indicated in the negative that that would be something that we could require, because I was specifically concerned about requiring undergrounding or going through the exception permit or the exception process, and I believe your comment at the time was you thought that might be more burdensome. Has that changed?
It's quite restrictive to say all non-antenna equipment in the whole city should be underground. Is quite restrictive. Kate said we can talk and we can look at the city code to see how all other utilities are regulated in given areas. But if there's no other city policy requiring anyone else to be underground, then like you said, that there may be a chance of a challenge because the carriers are the only ones being required to do it. Again, we haven't, no one has determined what similar infrastructure means when the FCC says that, but you may go to court and find out. It just depends. But we can look at the code and see. I'm not sure how other utilities are regulated.
But but you know our view on this, I think, to be restrictive if.
You would like to underground as much as possible.
Right, and then they have to ask for an exception if they want.
And also think of it as an interpretation too, the way the rules are applied to telecommunications in the right of way. The different rules are applied, there are special rules that are applied to small cells that don't apply to other utilities. So it can be looked at both ways. So let's think about it that way too and think about the best interest of the community. It's a win-win. We're talking about reasonable, right? What's reasonable? Can it be done? Can we request it and it still be reasonable to reach their objective and meet our objectives at the same time as a community? So that's how we want to look at it.
Okay. Reasonable, objective, no more burdensome than those applied to other types of infrastructure plans.
And legal. Okay.
Those three things would be the
Chris,
criteria that the FCC, I mean, that's all design standards, but the FCC, when discussing undergrounding, it's in paragraph 90 for him, Chris, but they basically said that the same criteria for aesthetics generally should be applied to undergrounding requirements. And they clarified that a city would not have to go so far as requiring that all facilities be deployed underground to be considered an effective prohibition of service. So the key is just applying those same aesthetic regulations to an undergrounding requirement. So we can work with staff, but generally requiring undergrounding in the whole city, if that's not already a policy, is a pretty restrictive stance to take.
Okay, Chris?
And this is just a reminder to Katie, if you do go down that road, to also include 5A, 1, 5B1, and 5C1 in that change. Page 8B50 and 8B51.
Oh, we're not there yet.
Yeah, but if they were going to make those changes, they should include the changes at the top.
Because these are, we're talking about general standards, so that should also apply to the specific standards, yeah.
Yeah.
All right, anything else on page 46 or 47?
Hold up.
Okay. Page 48. Bart.
Yeah, I think I'd like to see us go through each one of these for prohibited locations. That's the most important thing on here.
So,
and let's just go new poles, for example, not an existing or replacement pole, utility pole and similar in right-of-way. That is a prohibited location. Everybody comfortable with that?
New poles?
You're adding language.
Yeah.
No.
No, we're
just going through them.
Okay, so how about B?
Location of antennas directly at window height of adjacent buildings within 200 feet unless the facility is entirely screened from view of the affected building. I'm good with that one.
C?
Now, the next one, within 100 feet of historic property as designated on the city's list of historic resources. I'd like to see that increased. Does anybody have a problem with increasing 150 to 200 feet? Aesthetics. Putting some modern technology in front of a historic house. I mean, we're requiring people within 300 feet to alter their houses if they're impacting a historic residence. I think the same should hold true for the towers, the poles.
And it ties into our existing language.
Yeah.
Yeah, I'm on board with that.
Within the affected area around a historic property, adjacent property owners and within 1 or 2 property lines, which would be a decent distance. We require them to be sensitive, not block the view, not affect the view.
They need a cultural.
They got to get a cultural heritage permit for adjacent properties. I'm sorry.
Just to clarify, so we're all on the same page, currently a cultural heritage permit or minor cultural heritage permit, depending on what's proposed, is required if a single-family home is making a change, if it's abutting a historic structure or a historic resource.
Can be across the street also.
Right, and that's in the definition of abutting. And then it's within 300 feet only if it's more than 2 residential units. So it's not quite apples to apples, but we can certainly look at making changes.
Looking at, I'd like this to be just as restrictive as it would be for any other construction that would affect the public's view of the historic structure.
I'd be comfortable going to 200 feet on that. I think 300 starts getting
I think that's a
fairly
little
wide.
much, but
200, it comes in place with the immediately preceding
yeah,
section.
we go as far as dictating
And
sidewalks.
they can still have an exception for
everything
that,
in here.
right? Katie?
You can
It's not
ask
a
for an
prohibition,
exception
it
to
can be
anything in this.
I'd kind of lean back towards what the ordinance states, you know, the heritage, the cultural heritage.
Yeah, look for the
ordinance.
verbiage out of the.
I mean,
Not a cultural
I think we're on firm ground there, and if it's like a minor for a residence, it's like you hit the pins of the property line and across the street, the abutment thing comes into play, rather than go out to 200 or 300 feet.
Are we suggesting a minor or a regular cultural heritage permit for one of these, or not?
So, wait a minute.
No, we couldn't, we don't have time to
Yeah.
do an
So
HCP.
why do we even have
You don't have, the
this?
shot clock doesn't allow that. So,
Why
I
do-
mean, it's just a matter of you're trying to mirror image. If you want to increase what she has here from 100 feet from historic property, is just conform to
The design guideline standards.
the design guidelines standards of the minor cultural heritage permit, which is a little bit, just probably about 100 feet, but maybe a little bit more, depending on the lot lines. I mean, it's not that much of a difference.
Why do we even have
You're on
this?
firm ground by protecting, and I like the fact that we're protecting historic, we mention historic structures in the ordinance. I think that's a needed thing. I think it's a good thing, but I don't, there's this fine balance of where you go with it.
I support 200 feet.
So why do we even have the 100 feet in there? Because isn't the ordinance already capture 100 feet?
Only if the,
If
only
non-
if
non-residential.
it's a residential property line.
So what are we saying we like, 200 feet, 300 feet? Is there a preference?
I support 200.
I'd pull the language.
I was almost thinking just apply the same standards that the cultural heritage permit requires. There's,
The abutting,
well, it says abutting, but it can go kind of any distance. We've gone around curves a little bit and saying, you know, you got to change your landscaping and whatnot to keep this thing visible. You can't block the view, impact the view. And I think it may be, if you could look, I think the standards in there should, if we apply existing standard. I don't think we said we're making this more restrictive than anything else.
But make sure it doesn't loosen it.
My only question would be, so the thresholds that we currently have in the zoning ordinance rely on what the structure is that's being created. And that would be, or modified or repaired. And if that structure is residence, a single-family residence or a duplex, that's abutting, it would need to do a certain permit. And if it's a 3 or more residential structure that's within 300 feet, it would need to do either a cultural heritage permit or a minor cultural heritage permit. So we want to prohibit them in these same locations. This is neither a residential structure, nor does it have any units. And so while I understand what the commissioner is saying,
Landscaping also.
and that's only when your review is even triggered by one of these other underlying triggers in that application section of our zoning ordinance that sets forth when cultural heritage permits and minor cultural heritage permits are required.
Okay, let's just take that part out of the discussion. Let's just look at a separation from sensitive uses, and we'll call this a sensitive use.
I'll go 200 feet.
You know, yeah, if we
But-
put it, otherwise take it out, like Commissioner Talley said, it's 100 feet, it's already 100 feet from residential, so what's the point of even having it unless we're going to put something
Well,
restrictive on there to protect
Because
the
we have
resource?
commercial buildings. We have commercial historic buildings.
Commercial.
Okay, good point.
But if we can research that a little more.
We should have something.
There's probably a
more
loophole in there
restrictive.
somewhere.
It sounds to me like there's sort of maybe 200 feet is the easy way to do it, you know, splitting the difference, so to speak. But yeah, because it's.
And if it's shielded, or if it's not visible, it doesn't really matter.
Well, we would need to write that in, I believe.
Well, that's what it says right there. It says, unless the facility is not visible from the right-of-way directly abutting
Right,
the historic
right.
property.
Okay.
So then it's not impacting the historic property.
Yeah, correct.
There's
Okay.
mitigation.
I'm good with 200 feet.
Okay.
Or we can combine the C with I, or with J, because both deal with,
I think 200, I agree.
C and J both deal with a historical structure.
Yeah,
that's
but-
different.
Well, staff put it differently, so let's, you know, let's keep it there for staff. All right, how about D, strand-mounted facilities? E, within 200 feet of another existing approved or planned wireless telecommunication facility. I actually had something on this. This came from our last meeting. I think Bart brought up the good point of we don't want to have new poles installed in the city if we can avoid it. So we had a 300-foot separation, and Bart was saying, as I recall, hey, if you got to put up a new pole to have 300 feet away, we'll give you 200 feet away if you do it on an existing pole, so that we can reduce the number of poles. So this is worded a little bit differently, I think, than what Bart proposed, and I would,
That was the intention.
yeah. So I think what we would, what I believe kind of our intent was, it's 300 feet, and in speaking with staff about this, this may actually just be a staff guideline that says, yeah, we'll automatically approve an exception of 200 feet if it means they're not installing a pole. But in here, in the design standard, we have 300 feet. Now, correct me if I'm wrong, Katie, is that the most convenient thing for
Are we going
staff?
to call it a formal exception as it applies to the other application here?
I think that's the easiest thing for staff, and staff, correct me if, you know, if I'm saying anything wrong, but just say it's 300 feet, and someone comes in and says, I want it 200 feet, you know, I'm going to install a new pole here, and then staff would say, well, you can do it in 200 feet if you don't need if you don't do the pole.
Well, the new pole, in A, the new poles in the right-of-way is prohibited, so I like this language to be reconciled somehow.
So, Katie, did you want to chime in or correct me?
Yeah, well, you know, I wrote it, so it makes sense to me, but obviously it doesn't make sense to everyone. So we can definitely look at tweaking the language. So already, if a new pole in the right-of-way is proposed, they have to apply for an exception. So I can reverse how this is worded, and it would still, so that, you know, it says 300 feet separation required for,
New poles.
yeah. But that, I think, places the, I can reword it if you like, but an exception is already required if they're stabbing a new pole.
In part of that exception process, they'd have to demonstrate why they couldn't go to an alternative location, which could be
Right.
an existing pole within
And-
200 feet.
And each time staff is putting something that seems redundant, it's possible that it is, and we should talk about it. But in most cases, it's because it goes back to this finding of the exception that requires that they show that they're taking the least amount of, or that it's as compliant as can possibly be. I forget how it's worded at this point in the night. And so by having it both ways, or both places, or like we said, you can't put it on a historic structure, then they'd be needing to take multiple exceptions potentially, and would need to be proving why each one was necessary.
I'm fine with that. It makes perfect sense.
Okay, so we're agreed that that should be 300 feet, and staff will either word it or provide some sort of mechanism to allow.
It's clearer.
You're right, to allow that if 300 feet is going to be a pole, they can do it within 200 feet on an existing pole if that works for them.
Okay.
Okay. We good with that? All right. Anything else on page 48? Oh, I'm sorry, I'm sorry, we're going this one by one. So how about F, within 100 feet of residential or mixed-use property?
This is the one the public's most concerned about.
Yeah.
So is everybody happy with 100, or you put a higher number and then they have
I'd like
to
to
use
see
an
a high-
exception, or is this
Yeah.
good?
Here's where the rubber meets the road.
I'd like to see a higher number.
The problem, well, as we saw in the study sessions, what worries me about that is a higher number feels more comfortable, but on the other hand, then everything's going to become an exception. And I think then that becomes a problem, because then what we've written here means nothing if everything's an exception. So I worry about that a little bit.
I have some comment on this 100 feet from a residential property. I think in order to avoid being considered a de facto prohibition, we need to make those arterials available to wireless industry. Arterials are, just to name it, they're Pico, Vista Hermosa, Estrella, and De Los Amores, El Camino Real, and La Plata. Most of them have the right of way about 100 feet. Some are slightly narrower, some are a little wider. So if we have 100 feet and the residential parcel is on one side, assuming there's a little setback, it's safe to assume that those micro cell towers can be set up on the other side of the street. If we have it if we increase the distance by too much, then suddenly those some of that arterials will not be available. That will create a real problem for the industry to cover the city. So I think 100 feet is reasonable.
And we saw that on the maps, right? I mean, that's
Yeah.
when we saw
Yeah.
that we had those maps and we took a look at it.
We
and that
eliminate
was-
the arterials if we go more than 100 feet.
We
so-
cannot eliminate those arterials.
Well,
That's
we're
not
just
a-
going to get sued if we do that.
Right.
Well, we're more
That's not
likely to
defend-
eliminate any residential street, for sure.
We already eliminated residential streets, pretty much.
Pretty much.
Right.
Yeah.
So no, elimination of arterials are not defensible.
That's what the GIS plots show, that's what we kind of drove by. Right? Nobody's comfortable with it, but the terrain and the data shows us that unfortunately, that's where it's at.
Okay. Next one, within 500 feet of existing public or private K-12 schools, as measured from the property line.
Just to make sure that's just K through 12 schools, public and private.
Yeah.
I have comments on that 500 square feet, 500 feet from a school. As long as it's overall, the whole package does not prohibit, it's not a material prohibition. And the city has a lot of discretion to regulate as she sees fit. And this local land use regulation is not subject to strict or even moderate scrutiny by court system. It's ordinary scrutiny, and it means as long as there are some justification for public interest and welfare, it will be okay. So the justification is, for example, this can be easily make up some justification. For example, aesthetically more pleasing environment is more conducive to learning. So, it's a little stretch, but the court doesn't ask for much justification. So I think we're okay here.
Yeah, I don't think anyone's arguing that we want, we're proud of schools, we want them to be, nice looking and things we can be happy with. So I don't know
Right.
if there's an argument with that. So, Chris, did you have your light on?
I just have a question. The way this reads, does the school have to be a K through 12 school to fall within this prohibition, or could it be a K through 6?
Or 5.
Because it's not clear.
Oh, well, this is anything between there, right?
Well, that's not.
That's what he wants to make sure the wording.
You mean? Okay, good, we'll clarify that. So any school, even if it's a single grade, as long as it's between K and 12, okay.
I think he's way involved with the school.
It's a school for primary education.
All right, let's see. H, any location with a very high fire hazard severity zone. I guess that's a new acronym for me, VHFHSZ.
Say that 5 times fast.
No.
Just out of curiosity, why did we put that in there?
That was added based on public feedback.
Okay.
Because if it got it to be further from homes, why
Yes,
wouldn't we?
There was also public feedback that we put these in open spaces, which are almost always, if not always, very high fire hazard severity zones. Staff was simply trying to do the things that seemed reasonable that the public had asked for.
But Katie,
It might be a good alternative in some strange location. Would an exception be allowed?
Exceptions are allowed to any provision of this ordinance.
But it would have to be requested by the applicant. We couldn't force it on them.
I think in our review, we could ask them why they didn't consider something. If we felt that an exception to that would be better if it got it, for example, further from homes.
Okay, as long as we have the mechanism to do it.
do you have a map to show us the zone?
You know what? Orange County Fire Authority puts out a map, and I have that. I did not bring it with me this evening.
Okay. Toward the end of the Talaga, on the top of the hill, it's a high point, there's a macro site there. So is it even necessary? No one is going to put a micro cell over those places.
Water sites.
Yeah, water tank place. But if the residential district is in those very high fire hazard severity zone, then
Okay, within...
Real quick, before we move on.
Oh, I'm sorry, go ahead.
Back to the K through 12, can we include preschools? Just kindergarten?
Kindergarten.
No younger kids?
Why would you want to include younger kids, Chris?
It's still a school.
Why?
Why is it a school?
No, I mean, the preschool, finding the licensing on the preschool, you can have in-home preschool. We dealt with that with the Talega case not too long ago. So I think that would be a burden.
Some of the larger preschools still have 200 kids there.
I'm not supportive of including preschool.
That would be a hard one to enforce, because we have daycare and we have preschool, which are two kind of different things.
State regulated.
They spend just as many hours as any other.
Yeah.
Well, I think it's a valid question, but I'm a little worried about creep up the scope.
And we have to base it on aesthetics.
Yeah, it's an aesthetic question, so.
Okay. Unless you have wording you wanted to do, propose, Chris.
A word, licensed preschools. I understand, some of these schools, you're going to run into a larger density of smaller kids than you would, just like you would, an elementary school.
But we don't have a map to show the impact of this. So perhaps Katie can collect some information and present to the city council for them to look at it, or at least you can review it before the item goes to the city council.
Licensed daycare facilities are 12 kids and less, or less. Once you get above,
that's true.
Once you get above 12 children, then you need, it becomes a, full preschool. That means
becomes
state licensing.
Childcare facility.
Childcare facilities.
We would need to modify definitions to make this in any way understandable. There is I think some overlap in some of our definitions currently. And one challenge that we do run into is that these are less static than your typical school site that includes children K through 12. And so what I mean by that is school-aged schools, once established, tend to remain there. It's not necessarily the same with a daycare facility, and moreover, if we do include childcare facilities, in-home childcare facilities, we can't even acquire a list from the county of these locations if they're for small, which is 8 or fewer. For safety reasons, even if you identify yourself as a city, they will not release you the addresses. And we can't, we don't have a zoning permit for them because the state precludes us from doing that. So there are some challenges for staff in expanding that.
Yeah. Although childcare centers are defined.
They are? Yeah,
And
so if we
available.
wanted to exclude in-home daycare facilities, we could. The reason we did not is because they tend to move around more. It's harder for us to map, and so we would have to do an entitlement search each time one of these came in, or map them each time they came in, which we can do.
I think it's a valid point. I mean, one example would be the early explorations, used to be, or it's Bright Horizons now, up on Frontera. That's a full-blown school, and it's all through preschool. I mean, they've got classrooms, they've got a cafeteria, eating area, outdoor play, and the kids are there all day long.
I think they have 250 kids there.
I'm sure.
Look
So,
into that.
I think that would be,
Well, I need to see an updated map in order to support that. Otherwise, I cannot make that call.
but here's the thing, that site has macro sites, at least 2, right across the parking lot at the church. At least 2. Okay, at least 2. Is it 4? So, it's more than one.
The planning commission, members of the planning commission have the floor.
Yes, thank you. So these are, I mean, just on a side note.
Where's this located?
It's up on Frontera, just above Pico, up on the top of the hill.
Yeah, where the church is parking lots. Right? Yeah, where Goodwill is.
Where the giant white cross on the hill is, above the freeway. In fact, that's a cell site, the cross is a cell site.
What's the aesthetic justification for it?
Subjecting the kids to
visual blight.
Too much technology.
Oh, so now you put that on the record.
Right now, they look at it
So,
and they see nice.
Now that that's on the
green
record,
space
there's
on
no
the
way we
hillside.
can make that determination.
Yeah.
Something to look at.
Yeah.
Okay.
I'm a little worried about the complexity. It's yeah, so.
I think leave it as.
So we've got, let me take a little straw poll so we can give direction to staff. Who is in favor of leaving this text on G the way it is? And so
I think it should be schools in general, up to grade 12.
the problem is, yeah.
I mean,
But
by
we have those,
definition.
we have those problems with preschools. There's some in residences and they move around.
Well, non-residential, that would be an exclusion that Katie mentioned.
It's a straw poll you're trying to get to there.
Yeah, we've got, 3. I'm sort of on the fence, but.
So that's 4.
So what would be the, well, why don't we try this, because we're, okay.
Instead of kindergarten, go down to TK, because most legitimate schools
Pre.
have.
Pre-K?
Yeah, pre-K.
I like that.
Yeah, pre-K through, those are established schools. Right.
They're not daycares.
Okay.
So could staff
I'll
look
just
into
repeat
that? I'm sorry. Sorry, go ahead.
I'll just repeat my concern that now that we've gone on the record as saying it was technology.
When I say
we'll
technology,
remove it.
visual
I
seeing
worry.
a pole, not
I worry about the record.
Puts out.
I think I already offered a justification that is aesthetically pleasing environment is more conducive to learning experience.
One of our goals is just not to have a forest of these, right? The aesthetically unpleasing forest of antennas. But maybe, because I want to make sure we move with this if we can, staff can look into putting the text of pre-K and seeing if.
We would need to define pre-K.
Is there,
It's the year before kindergarten.
is there a legal definition of that? Like there is for.
Because pre-K would be different than TK. TK is a specific age range from September 2nd to December 1st birthdays. The kids that birthdays fall in there that just missed the cutoff for kindergarten. Pre-K is something that is somewhat nebulous and not defined to my knowledge, so we would need to define it.
Okay. School district define the year before kindergarten?
The school district, to my knowledge, but I have not looked into this is only based on my experience with Capistrano Unified School District. I just told you what TK is, and they have a variety of preschool, but that is for ages, I don't know, 3, 4, 5, or potentially 2.5 to 5. I don't know, but I don't know that it's an accepted standard. And so I would say we would need to define it, and I would appreciate, like, if you are meaning the year before kindergarten, that's going to be different for each student. So I think we would need to define it further. So
It doesn't sound like, I mean, the question is there an institution? You can point at that and say that is a pre-K institution, and if we can't do that, then I don't think that we can create that as a
We're
standard.
just trying to just be all-inclusive in that spectrum of schools. And if we can just include everybody, then let's just do that.
it sounds to me like we would want to define preschool as any licensed facility providing even like schooling and/or childcare, because many childcare centers, like the one you mentioned, call themselves schools, but to the licensing people, they are childcare centers.
So we want non-residential.
And we would just say non-residential childcare facilities or preschools, yeah.
I don't think we're going to get to that, it doesn't sound to me like we're going to get to that definition tonight. We can leave it, in the interest of hopefully moving this on to city council, we can leave it to staff to investigate and see if they can get a very crisp definition of that, like we have for K through 12. And if so, we might say include it because it's a school, it's clearly a school. But if we can't define it, if it's not clearly a school, then staff can leave it like this.
I was just going to add that preschool is defined, or it's categorized with daycare centers. And so preschools aren't defined as a school in the code, right? So schools are identified as elementary schools, junior high, high school. Preschool is identified with a daycare facility.
Yeah, so in the interest of not making things mushy, then let's just keep it to, my preference would be to keep it to the clarity, because this is tough enough.
I support it. I would say if we were to approve this resolution and we added direction to staff to do some research in terms of location, definition, and maybe mapping, and then consult with our legal counsel to decide what to be presented to the city council.
But you have to make sure that you can demonstrate this on a map, right? Because you can't ask a carrier to come in and not know where they are, right? So they have to be clearly mappable. I mean, that's a critical component of it. So when you're doing your research, Katie, make sure that, that's there, right? Because you can't play hide the ball.
Yeah, if you can't put
guessing game.
If we can't clearly put our fingers on what a pre-K is, then I think, if I'm speaking for the commission, then I think that leaving the text as is would be the preference. If we can clearly say it, that's pre-K, then we would add, then our recommendation would be to add that.
I think the city planner just read the code to us, how they define it already, so that it pretty well preempts anything.
So if there's,
and I do think
if there's general consensus, then I think and staff is clear on our guidance, then I think we're good with this. Okay?
So guidance is to leave it as is.
No, the guidance is staff is going to research pre-K, and if they can get a clear definition of pre-K, like we have with K through 12, then they will add this. If they can't get a clear definition, then we'll leave it as it is.
Well, they can have a clear definition as well if the addition of pre-K does not create a substantial larger area where microcells are not allowed.
Are we suggesting to class on, staff on this G also that it's non-residential schools?
Yeah, that's to the point of ancillary versus primary use. So if it's a church, that preschool would be ancillary to the primary use. If it's at a house, it would be ancillary. We already have restrictions on residential buffering, right? So that would override it. That would not, and this would be more for a standalone facility.
Do we need the wordage in G, within 500 feet from existing public or private K-12 school, as measured from the property line in a non-residential area?
Here's, you know what, it's after 10 o'clock. We're at the risk of running down rat holes. What about this? You can research pre-K and just pass that on to City Council, our concern about including pre-Ks? Is that, so City Council will hear it, and they will know that we have a concern about it? You know, A, that these are covered, you know, as an aesthetic reason, but also we want to be clear, and if we can't be clear, then we have issues with that.
I will throw one thing out. We had an application from, I believe it was a church school, and they actually ran preschool through 12th grade. I think it's up in the business park. Is that the one on Frontera? And it's part of the K through 12 school.
They'd be covered.
They would, because it's in the same building. But just so you know, there are schools that have both.
But they'd be.
Yes,
It's
I
easy
agree
to
with you.
find.
I agree with you.
Okay. Are we ready to move on from this one?
Yeah.
All right. I, within scenic vista corridors is defined in the San Clemente General Plan and local and coastal land use plan. Any issues with that? Restricting on, prohibiting it from there?
We're not protecting views, though.
We do in view corridors.
Yes, view corridors,
Okay,
yeah,
okay.
specifically. Anything with that? J, attached to historic resources as designated on the city's list of historic resources.
Good.
K, generators are not permitted in any public or private right-of-way. And I, wireless facilities are prohibited on traffic signal poles.
So why did we do that?
Engineering wanted.
Engineering.
Okay.
Yeah, traffic engineering. Okay.
That was a comment that came in. I was just, I couldn't remember why.
Yeah, it was specific to traffic engineers, so. Anything else on page 8B49?
I think the noise section, we've got several comments about the noise, so thank you for including that and making sure that that'll stay below the, I think it is the 50 decibels that's allowed from the property line, so.
Page 8B50.
I have comments.
Yeah.
So it's for 50 and 51, but 50, and, you know, I'm sure Katie can address this, and if not, maybe Andrew. So we have maximum heights on these poles. Can you please explain how 6409 would or would not apply here when it comes to expansion up to that 10% envelope increase, if it would apply? How would we address that?
Okay, so the standards here are dealing with installations on streetlights that almost certainly will not currently have any sort of wireless facility on them. I mean, I guess they could, but generally the carriers don't want to co-locate on light poles or utility poles. So once one goes in, 6409 would come in if a request to modify that existing wireless facility was submitted, and you would look at whether it meets all the requirements that are kind of articulated in federal law. And so these restrictions here are more geared towards what the initial installation will look like. as you noted, there are, in the federal law, there are certain like percentage increases depending on if the facility is inside or outside of the right-of-way. And so you would just kind of have to look at those and see if it qualified as an EFR or not. And generally one element of eligible facility request is that it does not defeat the concealment elements. So perhaps you could have some argument that if if it qualified as an EFR, but it's still, due to the height increase, potentially, I guess, eliminated the concealment elements, it could be kept out still. But generally, these design standards are geared towards the new facilities coming in, not the modifications to the facilities.
Okay, so, thank you. So that provision allows for an expansion. So are you saying that even though there's protection there for an eligible facility, if it's within that envelope, is there really protection when it comes to aesthetics in our decision making here? If we decide, no, that's just too darn high, we don't want it.
If it qualifies as an eligible facility request, then the city's discretion is very limited.
So we must approve it for the most part?
For the most part, if it qualifies, which would be a host of things in terms of how much it increases the size. I think practically what you will see, not a guarantee, but as far as EFRs in the right-of-way or eligible facilities requests in the right-of-way is going to be antenna swaps. And I know that had come up in terms of, hey, what happens if it switches from 4G to a 5G antenna? They'll have to go through the permitting process, and I think Katie had said that, but just to reiterate, they'll have to go through an application, will have to come in. Even if it is an eligible facility request, they still have to go through the permitting process. It's just that the city has less discretion to deny it if it's an EFR.
Okay. Okay, thank you.
Okay, anything else on page 50?
So does everybody understand that? That all of these are subject to some change later on, a little bit of change later on? Okay.
Page 51? Page 52. I had one item, this would be at the top of the page 3, whatever that's 5C3. We're saying that these poles are 35 feet or 10% taller than other similar poles not already containing small wireless facilities. That means that these slimline poles could be as tall as a current light pole plus 10%?
Correct.
Okay. So my understanding is one of the reasons why these antennas can go so high is because they're trying to get above the mechanics of the light. My question is, if it's a slimline pole, why can't it be shorter?
That's the FCC definition right there, I think, isn't it? Because they asked about that.
That's the minimum FCC?
So they do, the definition of a small wireless facility, I believe, does allow up to 50 feet in height. But is our position that definition's purpose with regard to the different volumetric limits is only used for the purpose of determining if it qualifies as a small cell facility for shop clock purposes. We don't feel that those size limitations are some sort of requirements that cities have to allow up to that amount. So this is not uncommon to see like a 35-foot height limit on the pole.
But we're also saying if it's, if we're just in a row, we've got a row of light poles, and then at the end, there's no light pole, and someone needs a slim line on there, we're saying that slim line can be as tall as the existing light pole.
Yeah, well, I guess, and this is maybe not as much of a legal thing, but just something to consider from hearing a lot of feedback. Would it look odd to have a shorter pole aesthetically than if, I think the intent is usually to try to just make it blend with the poles that are already there, given that cities generally don't want new poles in general, but if they have to have it, they want it to try to blend in, so I think that was part of the intention.
The reality is that another pole, the reason they probably aren't going on another pole is it probably already has a small cell site on there.
It's a possibility. I was thinking more like this would be usually at the end of a line of poles or something like that, or in a place where there simply weren't any poles at all, no utility poles or something, or a street without streetlights.
That
But
doesn't matter.
yeah, okay, I'm fine with that. Anything else on page 52? All right, then we move on to the wireless permit standard conditions. page 53. Anyone have any comments? Page 54?
I'm sorry, if I may, Jim, go back to 53.
Yeah?
Katie, do we get any input from the wireless industry on the permit durations?
Not to my recollection, and this is a standard condition that was vetted by BB&K. I don't think I've received any particular comments on that. It seems to be something that a variety of other cities do.
Yeah, so that would be a sunset clause on a land use, so it usually runs with the land, right? So we're adding that. Is that what that?
So under state law, the permits for these facilities have to have a minimum duration of 10 years.
Okay.
Outside of like some very specific exceptions. And so that's why it's generally, cities often set it at 10 years, so that way you have to re-up and any new standards can kind of be applied. Since that's a pretty long time in terms of technology development.
That's good to have that. Okay, thank you.
Anything on page 54?
We did get one comment, I think, from AT&T on the insurance, which, I think it was AT&T that talked, maybe it was Verizon, talked about self-insuring. What's, that's their thing? So do you have any cities that do that, or do they just keep this clause in?
So what I've seen, usually when the specific insurance language to that extent, like self-insurance comes up, it's usually seen, or personally I see it more in the agreements that cities develop for use of their city-owned light poles, like a master license agreement, and it comes up in the detailed insurance section. I think just checking to see if there's general language here that allows to switch it. The city, in terms of a general permit condition, I suppose could also include it, or perhaps you could, just give some authority to the approving authority to, and I guess they already do have it, to amend the insurance provisions to allow for, carrier-specific requirements.
This is a condition of approval, so staff can change that as necessary.
And I would generally say defer to whoever, risk management team.
Okay.
Yeah.
Anything else on page 54? Page 55?
Just for clarification, yeah, so Katie, back to that RF exposure compliance test, that is, or Gabe, it's a post-test that costs as a burden of the applicant, but it's just more like a secondary cost. It's not, we're not saying that's a fee that's going to be collected upfront and to be included as fee structure. So we're not violating that upper limit. It's like 500 report. Yeah, that's what we're doing.
And this is a one-time test, correct? Once it's installed, this is a one-time test and then no more testing? Or
That's correct.
is there any possibility to do some kind of regular testing every 3 years? Equipment, gets affected and people change frequently?
It depends on the facility, and it's going to, I think, change a little bit with this new order that the FCC put out. I'm still slogging my way through the, 158 pages, maybe more? I forget. Anyway, it's long and it's boring. But we're making it through, and BBK is going to help us out with a summary. But so depending on the type of facility. So currently, the implementing rules that the FCC has for RF has that you've seen it in the AT&T applications that came through. They have that RF worksheet where if they fall below a certain criteria, they are exempt. And it specifically states that they're exempt from any requirements of regular testing. That's not to say that the city could not take it upon themselves, as was previously mentioned, to test annually or however often we felt necessary to ensure that, cumulative RF levels were not being exceeded. It doesn't preclude anyone from filing a complaint with the FCC. But I do think that requiring any sort of recurring testing for these small cells, particularly with the new order that just came out in November, probably isn't very legally feasible, but that's my opinion.
Good, well, that's good to know. I think, obviously, then we couldn't do it as a condition of approval, which is what we're in right now, but I don't know, we may want to recommend that city council consider regular, testing.
Yeah, and I have a
Because
question.
if no one's testing it,
Yeah.
I mean, who should?
Yeah, so I have a question, and maybe Andrew could chime in on this. Do we have any legal, or any wiggle room at all as landlord? I mean, separate from all this permitting stuff we're doing here, the landlord says, hey, I'm not comfortable, I want to test every 3 weeks. As part of the agreement.
In terms of, so this, no. Essentially, no. The FCC gets into this in terms of acting in like a proprietary versus regulatory capacity. And essentially, they say in the order, it doesn't matter what term you use, or you just have to comply with the requirements in the FCC order. Thank you. So.
Anything else with page 55? 56? 57? And 58? All right. So that is the page turner. The question now is there any further comments or any motion?
I got a quick question.
Yes.
I got a question. For Mr. Talley Esquire and our city attorney. When I misspoke trying to say technological blight visually,
Thank you for
should
correcting that.
should I abstain from voting on the, would it be prudent to not go on the record and vote?
It's we could go around the table. It's my understanding that you meant blight caused by
Visual blight.
equipment. like
Yeah.
Thank you
technical
for clarifying.
component-
Thank you
technical
for
component.
clarifying.
Yeah, exactly, yeah.
Right.
Okay,
Just want to play the
That's my
game.
understanding.
okay, Jason.
I would actually just like to say thank you to Ms. Morrow and Newhausen for staying, and you as well for staying throughout this. I've noted that, and I appreciate your passion that you've been bringing here, and your tenacity, and all of your comments, which we've read multiple times, so thank you.
So I mirror that. I think it's important that we're mindful of the community's needs, the built environment. We're talking about, that's what we're talking about here at the end of the day, is what that visual experience is all about, and we're doing the best we can up here, and it's great to have such dedicated staff on such important issues, and having the community be present, as well as the industry. The wireless industry's representatives have been involved all along the way, providing lots of input and things to consider, so it's been nice. It's been a good process.
Don.
It's just a slog. It's been a slog. It's been tough. Appreciate the public comment and the other ones that have come. See how our hands are tied. Sometimes these things are frustrating to deal with. Sober living homes are just as frustrating. SB2 is even worse. And parts 2, 3, and 4 of SB2. Katie, great job, and BBK for all the support. We made you dance a little bit, but I think we're just trying to make sure we are our hands around this whole complex issue as best we can. And so anyway, it's time to move it forward. Good job on everybody's part.
So, and Katie, just to clarify, the resolution is for the ordinance, and, correct? And then the design standards and conditions of approval are our recommendations to council, correct? Do I have that right?
The way the resolution is drafted, it does also mention the design and development standards.
Okay, good.
I do not provide you with the council's draft of that resolution, though, yet, so I can see why that was
Okay.
confusing.
All right, no problem. Zen?
Overall, I'm pleased with this proposed ordinance. I think Katie did a great job.
It's one of those things that nobody likes.
We have to understand that aesthetic consideration is inherently subjective, but we've done as much as possible to make it objective. So The overall proposed ordinance provide a reasonable accommodation to the wireless industry with a safety valve, so they can seek exceptions. So, in the case someone is still not happy, I believe there are other cities that with much more restrictive ordinance, and hopefully they don't come down to us.
Mike? Oh, okay. Jason?
I just wanted to follow up that, as I mentioned earlier, the FCC did release a new study, notice of rulemaking and rulemaking last week, and they specifically were addressing their RF standards. And one of the things that they said in their order was that they were going to continue to monitor this, and they were looking for public input and scientific input. So I'd encourage everybody here to continue to send data to them, and they specifically referenced the FDA, the EPA, and the American Cancer Society. So those are probably some other avenues that are being considered by that agency. So again, just places that might receive comments.
I also would like to commend one of the speakers' comment citing the site into Spring. Many decades ago, when the industry started using those pesticides and DDT, and there was no substantial evidence to prove that they would cause any problem. So although only the heating effect is recognized, there's no consensus if there's any other health effects. So we just don't know. And we're precluded from considering that, but the possibility is still there. So I think to act with abundance of caution, especially when it's related to school children, beyond the aesthetic consideration.
Well, I appreciate that, but I truly do. But I just want to reiterate that we cannot consider health effects in what we're doing. We've got a couple things we consider, mostly design, and the concerns of all the speakers that we've heard notwithstanding, we have legal requirements we need to follow, both laws for us as well as what the city has to navigate through in the potential future when they're dealing with things. So just a reminder for everyone. Someone have
I'll have
a motion, perhaps?
I'll make a motion.
Sure.
That we adopt resolution number PC 19043, a resolution of the Planning Commission of the City of San Clemente, California, recommending the City Council adopt an ordinance to amend portions of Chapter 17.88 definitions, 17.28 special uses, 17.16 applications, and 17.12 development review process of the zoning ordinance to update permitting requirements for small wireless telecommunications facilities, and 2, adopt a resolution adopting the design and development standards referenced in the ordinance. And I do believe we had one change, if memory serves, to change where was that one? Was it was...
In the ordinance itself?
No, it was page 8B48.
That's not in the ordinance, though.
No, but this was the design standards which we're adopting. 2C, to make that within 200 feet of a historic structure.
Friendly amendment that we also have a modification on page 8B47, 4.A, to remove the radios, and then on 4.C, to change the wording to be equipment other than antennas.
So
Okay.
my question is, Katie, is that something we specifically have to change in order to make the motion, since it's not part of the ordinance itself? Sure.
City attorney, do we need to modify those on a dais?
Design standards.
So overall, it's a very short list. So there were 2 specific changes that I have that were requested. One was the 200 feet from historic structure separation requirement, and 2 was to clarify the requirement of undergrounding equipment. And that was not even a specific change. Certain specific areas would be changed, but we were directed to do more research to ensure that this would be legal based on, you know, where other undergrounding facilities.
So my motion,
And there is also the 300-foot separation.
What the additional direction to the staff to research
Yeah.
pre-K and its applicability to
so my motion is to change the one section to 200 feet.
My notes on that was that you were going to review if it's possible
Mhm.
to change it to 200 feet. It wasn't a direct
Right,
change.
because there are some map issues and that sort of thing. So these were, most of the, except for that 300-foot one for between the poles, and then 200 feet if they can avoid installing a new pole. Except for that, my understanding was these were all things that staff was going to look into to clarify.
So let me clarify my motion. I strike the amendment, and I make the motion that I made, and to have staff proceed with the directions of the commission regarding investigation and determination to council.
Second.
So,
Second from Don.
motion by Jason, second by Don. Just wanted to make sure staff is good with that, and Eileen is good with that.
Great job on, I know this is
I
hard.
am, yes. So between my notes and Eileen's notes, and you all will be reviewing the minutes, so pay special attention to those minutes when they come to you.
And the film, and the video. Okay, so we have a motion and a second. All in favor? Aye. Any opposed? Passes unanimously. Thank you, everyone. All right, next item. Design Review Subcommittee meeting schedule. I hope Stephanie wasn't waiting all night.
Thank you, Chairman. I'm not Stephanie, but I'll be giving the report. So this is for selection of design review subcommittee members for the rotating schedule. As you may be aware, that Commissioner Crandall, Commissioner Wu sit on the DRSC, but we have a rotating third member. And the schedule that we originally assigned for 6 months expires in January of 2020. So we created a new schedule. This was emailed by Stephanie Rojas to all the plan commissioners to determine if there was any kind of red flags. Perhaps commissioners may not be available, but Stephanie Rojas did make an attempt to create a schedule, and so this is up for discussion for the Plan Commission to see if this schedule does work for the Plan Commission. And that's going to include a rotating member and an alternate.
And I may be doing some traveling in the first quarter of next year, and I would request, Mike, maybe you and I can switch. I can take April and you could take February. Would that be all right with you? So can you take that back to Stephanie for us?
Okay.
If she could switch, as far as the rotating member column, if she could switch Rulon and Blackwell so that Blackwell's in February and Rulon's in April?
Okay. Sure.
Thank you.
And candidly, mine's all dependent upon the practice schedule that I get for baseball. Sorry.
Which is now, yeah.
I got roped into that again.
Okay.
And I'm excited about it, but.
Oh, and this is a voting item, correct? All right. Is there any more?
Motion to approve the schedule as provided.
And amended.
As amended.
Amended, as amended and provided.
Second.
Motion by Jason, second by Don. All in favor?
Aye.
Aye. Any opposed? Passes unanimously.
Okay.
And,
Motion to adjourn?
No, I got a report.
yeah, reports of commissioners and staff. Jason?
I went to the Coastal Advisory meeting last week. There was a presentation on a study that's being done on a pier. They're trying to figure stuff out. They've been trying to figure stuff out for a long time. They're still trying to figure stuff out. They did detect I think it's what, HN13. It's a DNA test that comes in that in the water that is possibly from human contamination.
but that's also present in recycled water, so it's too early to say whether there's, human waste that's getting into the ocean by the pier, but they detected that and they're having to proceed with due diligence to determine the source and if it's not from recycled water. So that's a problem.
Could be huge.
Yeah, it's not good, and they've got to get to the bottom of it very quickly.
Okay. Don?
I'll make a motion to adjourn.
Okay, as long as there's no more, doesn't look like there's any other reports, so make your motion.
I move that we adjourn to the January 8th, 2020 regular meeting of the Study Session and Planning Commission were previously canceled, and so I move that we adjourn to the next adjourned regular meeting of the Planning Commission that will be held on January 22nd, 2020 at 6 p.m. in the council chambers located at 100 Avenida Presidio, San Clemente, California, as the January 22nd study session was canceled due to lack of business.
Motion by Don, second by Mike. All in favor? Aye. Any opposed? Passes unanimously.
Merry Christmas, Happy New Year to everybody.
Yes.
And thank you, Ms. White, for your fabulous